the 11th of August. So we have two sessions happening today. We're going to have the final part of the inquiry dealing with landscape and visual impacts, and this will be the witness for Scottish Borders Council, Siobhan McDermott. That will be this morning. When we conclude on that issue, is the intention to have a conditions hearing. Now, an email has gone out from the office indicating that we'll either run that after a short break straight after, depending on where we are and how far we are into the morning, or we'll have it after a lunch break. So we'll just see how we progress on that this morning. Just covering matters arising, I just want to touch on the conditions hearing in terms of who's taking part. I've got the applicant. At the moment, I have Mr. Hardy and Mr. Ken Campbell. For Scottish Borders Council, I have Scott Shearer. For Dumfries and Galloway Council, Douglas Armstrong and Chris McTeer. And Forside Community Group, I have Mr. John Campbell and Miss Yvonne Jackson. Now, I haven't got Historic Environment Scotland down as taking part in this, as I presumed that wasn't a matter that they were going to be getting involved in. They didn't raise that at the examination meeting. Are there any other parties that intend to take part in the conditions hearing? Okay. Not seeing any hands. The names
Just, it's Keith Campbell rather than Ken Campbell. It's a minor point.
Ken Campbell from?
I don't know.
I must know. Okay, apologies, Keith. Really sorry about that. That's my abbreviations with K. Okay, so we're clear on who's taking part. And are there any other matters arising before we move on to today's session? Mr. Hardy.
Just one, and it's an update really in relation to Mr. Welch. He's still testing positive, although he's working and describes himself as feeling fit and well. What he is wondering, he's very keen because of the work that he's put into this, just to be there. He is wondering whether or not it would be possible for the client to provide two 4x4 vehicles. So he drives his own 4x4 vehicle, remains in the vehicle at all times, has no contact, but is the kind of able to direct people, make sure that people are in the right locations. So to have no contact and to be isolated in his own car, with the client providing two 4x4s otherwise.
Okay. Presumably he will leave the vehicle and walk around with us though and talk to us about those things.
I don't think so. I think he was. Okay. He's quite. I mean, I think that it introduces an element of risk which doesn't need to be there. He was suggesting to me he's quite happy to be in his vehicle, away from everybody else, and have no contact, but to be the effectively the guide. Okay. Are there any concerns from parties who are coming tomorrow on that particular issue? I've got a few names down. Ms. McDermott, you're down for coming tomorrow. Please raise your hand if there's any issues that people have with that. In an ideal situation, I would prefer Mr. Welch not to attend, and that is our guidelines. If he remains in his vehicle and doesn't mingle with anybody, and he'll have to have the air conditioning on and keep himself nice and cool, then and he's hopefully well, he may be the lucky one because he can stay in his vehicle and have the air conditioning on. So
yes. Then it may be that he's clear by tomorrow anyway. But we'll just
it might be, but I think just all right. Well, if that's acceptable, then I think that's what we would propose. So he will not mingle, not have contact, but will be there in his vehicle to guide.
Okay, all right. Yeah, we'll see you tomorrow. Thank you. Any other matters? Okay, good. We will move on with our first session dealing with landscape and visual impacts from Scottish Borders Council. Just 1 second. Mr. Kirk, are you there? Yes, you are on the screen. Mr. Kirk, could you introduce your witness, please?
Yes, thank you, ma'am. Council's witness is Siobhan McDermott. Her qualifications and background are set out in her recognition, so I'm assuming we're taking those as read. I only have 3 matters to raise with Miss McDermott and examination chief, so I'll be fairly brief. Those are arising from James Welsh's evidence, which he gave in the first part of the inquiry at the end of June. Can I just check with Miss McDermott that she's able to access the core documents? Apart from the council's inquiry report, I won't be referring to any but I appreciate that Mr. Hardy may want to refer to some of the core documents in his cross-examination.
Yes, I've got the core document list, the 4th of August one up, and I'm hoping that my bit of practice has set me up for pulling them up as I need them, if and when I need them. Yes, I've got them.
Okay, thank you for that. So I'll move on. My first question for you, Ms. McDermott, is in his evidence, James Welsh commented that siting a development gets more challenging towards the edge of hilltops. And I think he referred to striking a balance, and it was his view that the applicant had found a balance here. I appreciate you've looked at this from a Scottish Borders perspective, but would you agree that a balance has been struck with this proposed development?
Certainly in the course of the previous landscape and visual session, there was quite a lot of discussion about setback. From Scottish Borders Council perspective, the appearance of turbines stepping down off the upland hills into the upper reaches of the Teviot and Limey-Cleuch Valley, it's probably a location I would consider where that balance hasn't been struck, both to the detriment of those valleys and to the continuation of the Teviot Valley to the north and other elevated points along the valley sides in Scottish Borders Council.
Okay, thank you. Also in his evidence, James Welsh referred to the impacts on the A7 road as being intermittent. Again, I appreciate you've looked at this from a Scottish Borders perspective, but would you agree with that assessment?
The A7 is I just preamble this by saying that the A7 is signed as a historic route through the borders, so there is high sensitivity for that route. I certainly wouldn't dispute that the visibility is intermittent. Clearly, we can see that from the ZTV, albeit I have concentrated, when looking at this, I've concentrated on probably the 7.5 kilometres north of what is the viewpoint at Teviot Head from the A7. So from a point to the north of New Mills, the valley begins to open up where you get less tree cover along the roadside to help screen the views to the south. It begins to open up, and from there down to Teviot Head and the viewpoint, which I think is now called viewpoint 26, we are getting intermittent views. The point I would also make in this is that the road is largely facing directly towards the site, so there is very much more the view of the wind farm would be central in the view down that road and for users travelling south.
Okay, thank you. And finally, Ms. McDermott, Mr. Welsh was referred to paragraph 6.12 of the Council's inquiry report, and I think that paragraph states that the updated ZTV now suggests that larger areas of the Scottish Borders, which includes parts of Hawick and its surroundings, will have visibility of higher intensity lighting than originally identified. Can you clarify how you reached that conclusion?
Well, I basically looked at the supplementary information figure 6.9F, which is the lighting intensity ZTV, and I compared it with the one that was previously submitted. And in my reading of a ZTV, the much greater extent of the dark purple, i.e. the high intensity visibility of that high intensity lighting suggested to me, and that was contrary to what I had expected when I was looking at that I had expected, because of the reduced scheme, down to 18 turbines being lit. I did raise that query purely because of that, and I not sure that the reduced aviation lighting scheme, that the explanation there was clear about why that had happened. I think, yeah, so that was why I raised that query.
Okay, thank you, Ms McDermott. I have nothing further for you at this point of time. I'm sure Mr Hardy will have a few questions for you. So thank you, ma'am.
Thank you, Mr. Catt. Mr. Hardy.
Yes. Good morning, Ms McDermott. Can we just pick up before we go into list of documents and other matters? Can we just pick up that last point first in relation to aviation lighting? I know you were poorly, and I'm very sorry that you had COVID. Presumably, or did you get to listen to Mr. Welch's evidence?
I did, yes.
Right. And you will have heard the explanation for the difference in ZTV shading patterns between the original EIAR 2019 lighting intensity ZTV, that's CD2 150. We don't need to go to it unless you want to, and the other one that was included in the SI, that's at CD 4.3. So in the way you've just given your evidence in chief, it rather sounded as though, look, it was right to raise a concern, but now having heard the explanation, are you satisfied by what Mr. Welch had to say?
I clearly absolutely acknowledge what he said, and I think he said that if I'm correct, he said the parameters had changed, the way of producing that ZTV, or the parameters by which it was produced, had changed.
Yeah.
What I suppose, from my perspective, this is an area that I'm interested in, albeit haven't had a huge amount of experience in to date. If the two lighting intensity ZTVs had been the same, it would have been a much easier, perhaps, comparison to make. So in a way, if the first one was done on totally different parameters, it
So it was a query rather than an objection. Now that query was raised, and objection remains to the aviation lighting. Is that?
that would be. I would have serious. Yeah, I object to the aviation lighting.
Okay, but is that a summary of where we, just so I've got it right? The technical stuff has been answered. There is the substantive concern that remains. Ultimately, that's going to be a matter, isn't it, for the reporter?
Yeah, I'd agree with that.
Is that a fair summary? I want to put words in your mouth, and I just want an accurate note of where we are. And so technical query answered, but you retain your substantive.
The technical query is answered. It still leaves me a bit bemused by the very much greater lighting ZTV for the higher intensity lighting than was previously shown.
Yeah, but I mean, I don't want to open this up too much. No. The answer, but the intensity ZTVs don't provide an indication of how many lights are giving rise to the intensity shown, do they? So, yeah, I mean, clearly you've got 18 hub lights now as opposed to 45. It's substantially fewer.
It's absolutely substantial, and I think we acknowledged and welcomed the reduced lighting scheme for aviation lighting scheme for the for the project, albeit we have still, the fact that there is going to be aviation lighting there we have concerns about that, given the remote nature of the area.
So notwithstanding the technical concern, that's been dealt with. 18 hub lights, your view is there's still a substantive objection based on the impact of the reduced lighting scheme?
Yes.
Okay. That, I think, is all I need to deal with on that matter. It's a matter really for the for the reporter. There were three matters. That's the first of the three matters. The others rather larger, I suspect. The siting and design relative to the scale, character, and capacity of the coal crew head and Croik landscape character areas. That's issue 1, and then issue 2. The visual effects of the proposed development on sensitive receptors using the minor road to Common Bray and the A7. And then the aviation lighting. They're the three matters, aren't they, which come from the objection that the Borders Council put in.
That's correct.
Mr. Hardy, sorry.
Yes.
For some reason your video's gone off on my screen. Would you just see if you can correct that?
Right, I have.
He's on my screen at the moment. I'm clearly seeing him.
It's just me then. Oh,
Likewise, ma'am, I can see Mr. Hardy as well.
it's just me then. Okay.
Whether that's a benefit, I'm not seeing you, but you.
Okay, carry on. It's fine.
Those are the three matters that we were going to cover. But one, that first one we've taken out of order in terms of the lighting. Right. Let's go back to the beginning. I just want to understand your involvement in the scheme by way of a preliminary, Ms. McDermott. When did you become involved?
I became involved in the scheme when the application came in.
Were you responsible for the inquiry report?
I was, yes. I was involved in writing that. I did it jointly with my colleagues.
But the landscape parts of that, the things which you are really, the council is taking forward into this inquiry, that was your input.
That was my input.
Can you explain what field work you carried out to inform your assessment? Because in the inquiry documents, I can't see what you say you did or didn't do.
Well, I think in my initial response, so it is in the core document. My response in 2019, I listed the viewpoints that I visited, and I also said that I've driven up and down the A7 a number of times, and clearly it's in our areas. So, and following that, I worked at my desk, reviewing the information, reviewing the environmental statement and the landscape and visual impact assessment, and did my report based on our policy and other guidance.
In your report at 4.3, I know 4.2, so the Scottish Borders Council position on landscape character effects. What you say is upland types generally perceived to be more suitable for wind farm development due to the grandeur of the scale. However, the scale of turbines proposed is larger than any others which have been previously consented in the Scottish borders and may pose significant impacts on the key characteristics of the host LCTs. Were you involved in Crystal Rig 4?
No, I wasn't.
And are you aware of that decision? They were consented, I think, to 200 to tip the decisions before the inquiry.
I wasn't, to be honest. No, I didn't realise they were actually 200. But yes, yes, that's.
So you had nothing to do with Crystal Rig? It's interesting because the grounds for objection, just going back to the aviation lighting point, as well as the height point, it's interesting that the grounds for objection were very similar at Crystal Rig to those at Foresight. That's coincidence, is it?
Totally coincidental. We've got two landscape architects in the council, and it so happened the areas that we deal with are different. So yes, it was another landscape architect who dealt with that one.
All right. Well, we can leave that there. The reporter can see the report, and also the way in which the lighting concerns which were put similarly were dealt with by ministers. Ultimately, that scheme was consented by ministers. But if you weren't involved, I'm not going to take that further with you. In terms of your field work then and assessment, one of the things we don't see, it's a very short section in your section 4 of the report in relation to landscape character effects. I don't see any working or any assessment of the proposal against the Borders capacity study. Is that right? I can't see. I'm not going to find that in the inquiry documents.
No, you're not. I think you're going to be. If you wanted to dig into that a bit deeper, you might be better.
We are going to, yeah.
Yes,
we're going to go to the capacity study. I'm just interested in whether or not you had undertaken an assessment against what the capacity study has to say.
I would hope that my I certainly did make a judgment against the capacity study, because as I said before, I used the guidance and the SPG to inform my my decision or my assessment of the proposal. But in my original consultation reply, I think I clearly mentioned and discussed the landscape capacity study and how I saw this particular scheme fitting or not into the
It's rather odd, you see, because the objection, for reasons which we'll come to, appears to run counter to the capacity study, and the evidence produced by yourself on behalf of the council. We'll go to the capacity study, and I'll justify why I put that as a proposition. Your inquiry documentation doesn't include any workings or any assessment against the capacity study that we can test in cross-examination now, does it? There's nothing for us to see.
No, but if that's what you find, I think I will agree with that. But you might, as I said, be better going to my consultation reply, which was done back in 2019.
I'm interested really in the inquiry materials, and that was what the question was concerned with. I think the answer is that you haven't. There's certainly nothing post the inquiry procedures starting. There's nothing that I can see now which tests this scheme against what the capacity study has to say. That's fair.
If that's the case, that's.
It's your evidence, Ms. McDermott.
I know as that's the case, it was probably an oversight on my part in terms, or a misinterpretation of what the inquiry report should be going into and delving into. So that's possibly
it's a very substantial oversight.
Experience on my part to say that, but clearly if you go back to one of the core documents, which is my original consultation reply, I think I do give have a clear discussion about why I don't think it fits with capacity study.
Okay, I mean, oversight. I mean, the purpose of inquiry evidence, isn't it, to inform the reporter ministers about why the council takes its position. If it's taking a capacity position, it's very odd. But last question on this, really. I think I've got the answer. But it's odd that the council, doesn't provide the detailed breakdown of why it says we fail against the capacity study. So it's a surprising oversight, isn't it?
It is an oversight.
All right. The capacity study that it is a useful starting point. Can we agree? It provides a strategic overview for a site before site-specific factors are evaluated. Can we agree that?
Yes, it's absolutely. I would agree that the capacity study is a starting point from which further considerations are made.
Yeah, and one of the things in the policy, so policy ED9 of the development plan, you can go to it if you want, but just it's a simple point, requires consideration of landscape and visual impacts, including effects on wildland and cumulative impact. And that tells us, doesn't it, tells the decision maker that account must be taken of the renewable energy supplementary guidance and the Ironside-Farrer landscape capacity and cumulative impact study. So it's an exhortation in the development plan policy to go to the capacity study.
That's correct.
Yes, it's not a sort of luxury. It's one thing. It's a signposting from the development plan to go to that document.
I agree with that. No argument on that case.
So let's turn to the document itself. So we need to go to the Ironside-Farrer document,
which is I have a.
It's CD 10.7. It's split into a number of parts on the extranet. You may well have a hard copy, and I'm not sure whether it's divided in the same way on the unit's website, but I'm looking at part 2, so it's CD 10.7 Appendix C. I also want to have a look at some of the introductory work, which would be part 1. So if you've got the document, then I'd like to turn to the executive summary. So on my version, on the extranet, that is electronic page 7.
Interestingly enough, I will use the hard copy because interestingly enough, when I go into the one that the 007, it actually only starts on 16 or 15. So I'll go for the hard copy.
Right. Well, I want to make sure everybody, Mum, have you got the 3 parts? There was a question really directed to you, Mum, as a reporter. Have you got the Ironside-Farrer report, and have you got access to, well, first of all, the executive summary, which on the extranet is in part 1 of the files?
Just finding it now. Yeah, I've got them up. So as you say, it's split into various sections.
3 parts, yeah.
Yeah. Mm-hmm.
So we're going to need part 1 and part 2. As long as you've got the, Mr. McDermott, as long as you've got it,
yeah, I think it's CD 10.006 and CD 10.007. Part 1 is the 006.
Yeah. Right. Executive summary is where I want to be. And there's a paragraph which begins purpose of the study. Do you have that? Purpose of the study is to provide
Yes, purpose of the study.
Got that? Yeah, purpose of the study to provide detailed technical assessment and guidance on landscape vision and cumulative development matters for Scottish Borders wind energy supplementary guidance, part of the Borders local development plan, which we've looked at. Study follows on from the wind energy consultancy study July 2013, providing detailed information on landscape, visual, economic, public opinion matters, specifically updates the landscape, visual and cumulative situation in the context of current wind energy development and changes to Scottish planning policy in 2014. So it's a high-level introduction to what the study is doing. Page 3 Next. Standard stuff with capacity studies like this. Not intended to be a site-specific tool. And page 3, you'll see paragraph which begins, it is emphasized that. Do you have that? It's emphasized
Yes.
This is a strategic level landscape and visual study providing context for considering capacity and the cumulative effects of existing potential future wind energy developments. No site-specific conclusion should be drawn from it in its current in relation to current proposed or future wind energy schemes. So you get this in all capacity studies, don't you? But it just makes the point this is higher level. It's a starting point. It's not to be used for project-specific conclusions.
Yep.
Just a couple of pages to the executive summary. There's a heading approach to the study. Just want to pick up. And there's a paragraph. It deals with expectation for future landscape as a consequence of wind energy development. And you see a paragraph, this strategic level study.
Mm-hmm.
You see that? Yep. So based on the premise that given current renewable energy targets, there will be a need to both acknowledge and manage future landscape change and effects on visual amenity resulting from wind energy development, and to identify where change is acceptable and where it's not acceptable. So 2 points there. One, expectation that wind energy is coming. Were you able to listen to the cross-examination in relation to capacity studies and whether or not they should be heading into the territory of acceptability? Were you able to hear that?
I certainly heard the discussion, and I presume you're talking about both Mr. Welch and Ms. Anderson.
Yes, you heard that. I'm not going to repeat that question necessarily, but you heard that evidence.
I heard the evidence.
Next reference, just want to pick up executive summary under the heading landscape capacity and cumulative development. And it's a paragraph beginning the underlying capacity for different sizes of turbines.
Yep.
You have that? That comments, doesn't it, on where capacity may be found in the Scottish borders, and it's important. So if you can just read that, it's page 7 of 42 on my electronic version. The underlying capacity for different sizes of turbine across the landscape character types of the Scottish borders shown in detail in figures 6.1 A to E. We'll go to those in a minute. Extensive upland areas such as the Moorfoot, Lammermuir Hills, parts of the southern uplands, tend to have the highest underlying landscape capacity for the largest sized turbines in wind farm developments. That reflects the suitable characteristics of scale, simplicity of landform, lack of small scale boat development, and there are nevertheless many smaller or more topographically distinctive upland areas such as the Pentland Hills of greater prominence and visibility in the landscape or have national or local designations in recognition of their intrinsic scenic, cultural, recreational qualities, greatly limiting underlying capacity. Other areas, including much of the central southern uplands and Cheviot Hills, are combinations of scenic, recreational and wilderness qualities often recognised by designation, which also limits underlying capacity. So I've read that in full. But the important point, present purposes, I'm going to suggest is that sentence, extensive upland areas, the Moorfoot, Lammermuir Hills, and then parts of the southern uplands tending to have the highest underlying landscape capacity. So at the highest level, this part of the area is seen as having the highest capacity, isn't it? The inherent underlying capacity to take wind turbines.
I would absolutely agree that upland type landscapes have the greatest inherent capacity for wind farms. We talk about when we go in, dig into that, it's the scale, the simplicity of landform, that means that there is that there is an underlying capacity to accommodate these such wind farms. So yes, I would agree with that, and that has always been the basis on which we have initially looked at one of the first initials considerations we make is to the landscape character type.
And if we can then turn through to capacity study figure 6.1E. So in that run 6.1A to E.
Yep, I have 6.1E.
So what that's doing in the run of figures is indicating those parts of the borders that are assessed to have some underlying capacity for turbines in excess of 120 metre to blade tip as they relate to the landscape character areas. That's what the figure's showing, first of all, isn't it?
Mm-hmm. Yes.
The category is over 120 metres. That's the largest of the largest turbine category, isn't it, in the study?
Yep.
And over 120 metre category would pick up turbines such as those in the proposed development at say 200 metres tip. It would be included, wouldn't it, in
As it's 120 metres, it would be. However, there is I suppose there is a provision or a point to be made that when this capacity study was written, we were really not getting so we are small turbines and large
yes, turbines have got larger. It may be and just want to do with that point. Or on the express point is that the study doesn't specifically exclude 200 metre turbine.
from the recent of age.
No, 2006. That's fine. Underlying capacity, they're separated into 4 categories.
That's correct.
It's in which the proposed development is located. That's the Southern Uplands Forest. That's called what's the largest?
It certainly is shown like that on the map.
Well, I mean, that's the study. That's where
I would agree with that. Yes, that's
side. You've got one coastal area when you look at the land, how many layers, the is having a low undercapacity. Just at a bird's eye level, that's agreed between us.
the majority of it, large capacity is in the Crake area, and we do see that as it's obviously southern uplands with forest cover. So I think there is a good reason for that. Whereas it drifts into the for the coast area at that side of the A7.
Go on. I'll just stop you if you want to finish your answer.
Yes, I wanted to add on and say there's a note.
Have assessed through its capacity study as having any capacity to accommodate turbines of a height greater than 120 metre to blade tip and without limitation caused by cumulative effects.
Would it be fair to say that the site is on the very edge of that area of highest capacity?
To caveat that you can, of course, enter. I don't think it takes away from the point. There's no spray can painted lines on the ground, are there? These things bleed into it. Of course they do. But so far as the capacity study is concerned, towards the edge, fair enough. But it's within one of those few areas that is assessed as having capacity without cumulative constraint. That would be fair, wouldn't it?
In or just outside of as well, I would, obviously include that, because I think it's a little bit more nuanced than just within. But yes, in general, we are talking about an area that is shown as areas for highest capacity as dark green, and the site is adjacent and just tipping into the edge of that area.
Right. Just tipping back to that reference in the executive summary, then it's the one that we've read before, but that one which is saying that the forested southern areas of the central southern uplands, that's where the most remaining capacity is. If you're a developer and you're using this as you're told to do through the development plan, then it's a sensible place to be looking, isn't it, for wind farm capacity in an area that we agree is one of the few as being seen as having any capacity at all and without cumulative constraints. If you're looking for locational guidance or a signpost to take you somewhere, then it's a fair response, isn't it, to come?
Oh, yes, I mean, it clearly is. That particular 6.4 is titled opportunities and constraints. So yes, it would be, and the whole purpose of this is to give guidance. So yes, I would say it is a fair starting point from which you would look at sites.
Yeah. So it wouldn't be fair criticism to say, look, you've had no reference to any of this. This scheme's just been landed from the sky. It's in completely the wrong place. That's not right, is it? Your own documents, your own development plan, back capacity study would indicate that this was a sensible, logical place to start for the reasons that we've just been through.
Yes, and I think we all know that it is a starting point. So it's a starting point from which there would be a full range of considerations taken.
Of course there would, and it's got to be design, and it has to bear in mind sites, characteristics, and so on and so forth. Of course, it's about that starting point and where you might have your, where your scheme might come forward. And I think we're agreed that actually following that document through and your opportunities mapping, this is a sensible, legible place to go because the capacity study says so.
Certainly, there, I would probably phrase that there's potential.
Potential. All right. Okay, if we agree, sensible, legible place for a potential wind farm.
In that green, yes, in that green area, yes.
Sure, that's helpful. Thank you. Right, let's go to the study, the table itself. So we then need to look at the two LCTs, and we'll take LCT 4.3 first, if we may. So that is on my page 29 of 41 on the extranet part 2. I think the page reference in the hard copy document is page 39.
That's correct, yeah. We got that one.
It's just worth spending a little bit of time orienting ourselves because there's a lot of information on this page. You've got columns, well, a number of columns, and then a number of responses. So just reading from the left, the landscape character sensitivity is a test of a medium. It's med, yeah. That's right, isn't it? So I just read so on the left-hand side.
Sorry, I'm looking at that left-hand side 4, and we've
so
got.
If you look at the, yeah, I mean, it is quite. I have to say, it's dense with information, but you've got landscape sensitivity to wind energy development at the top left.
Yeah.
Then you've got landscape character sensitivity, which is written vertically.
Yes, you have.
Yeah. It is difficult to read, but when you that's why I thought it might be just worth taking a few minutes to do this. So landscape character sensitivity then is medium.
That's correct.
Next column along, visual sensitivity is low to medium, low med, yeah.
That's what it says, absolutely.
Landscape sensitivity medium.
Yep.
Landscape value medium.
Yes.
Then underlying landscape capacity confirmed for all 5 turbine typology, but then with a low capacity for the identified for turbines in excess of 120 meters.
That's correct.
Proposed limits then to future development confirmed for all 5 turbines with low remaining landscape capacity identified for turbines in excess of 120 meters.
So we've jumped across to
yes.
that. Yes, yeah, okay.
And then the maximum number of turbines, so we're in the third of the principal columns. Maximum number of turbines within groups in the LCT unit identified, I think it's 5 to 10.
That's correct.
And the proposed development here has got 8, hasn't it, in the LCT?
Yeah, I guess you could, yes, yeah, that's correct.
On, you were going to say something?
It's a maximum number in group, and I would, whatever the actual number in the LCT, the wind farm, I think the point that one is that they're making is that they're not wanting to go to the border and say, yes, we can have 10 in this area and 10 in the right next door, because immediately that, so I don't think that's the spirit in which that particular number is meant to be taken. I think it's probably reflects more the number of turbines in a scheme.
Well, that can't be right, can it? Because each of these units is taken separately, and it's not that, well, you can have 5 to 10 in one, but you can't then have anything next door. its capacity for each of those units. So whether that's one scheme or whether that's a scheme of 5 units in one, separate developer coming along with a scheme for 5 units, 5 turbines in the other, matters not. So it's not an either or, is it? These are, and also we know that there aren't cumulative constraints. So it's to be read, or it's to be taken at face value, isn't it? That is the number of turbines within that unit.
That wouldn't be my interpretation of it. I'm sorry.
So you think it should be that would be a
I would look at the piece underneath which says minimum group separation distances. So we're talking about when we have a group, we want minimum separation distances from other wind farms of 5 to 10 kilometres.
So it's in your view, I mean, it is what it says. What it says. But pepper potting, then, so you've got turbine or 5 to 10 turbines, and then gap 5 to 10 turbines, gap 5 to 10 turbines. That's what you think the capacity study is getting at, do you?
With more considerations than just pepper potting. Absolutely wouldn't expect them to be pepper potted, but
okay, that may be a pejorative term. What I mean is you've got a small 5 to 10 turbine wind farm, gap, small 5 to 10 turbine wind farm. That's how you read that part of the study.
I would expect them to be some separation between different wind farms, and I think that was already when you go across to the next column, it talks about separation from the windy, well separated from the windy edge wind farm. So clearly that was the reading I would take from it, that they're wanting to be separation between wind farms.
So recognizing here always that there's no constraint for cumulative effects, and Borders doesn't take a cumulative effect point.
We don't.
No. So whilst that may be a theoretical if I may just put the question, whilst that may be a theoretical concern, it's not a site-specific concern, because Borders doesn't object on cumulative grounds, does it?
No, we didn't on cumulative grounds.
Okay, thank you. Right, so if we turn to the analysis and guidelines parts, that's the 4th of the principal columns. We can read LCA is extensive open hill country, rolling hill landform, steep-sided valleys, more defined, and hills are more defined, taller than in Dun-Now LCA. However, they're significantly lesser scale than Broad Law LCA. Relatively little forestry with extensive areas visible in neighbouring LCAs, no designations of long-distance footpaths, little human settlement within or nearby area has lower intervisibility. And then you get to development capacity. There is remaining capacity for larger turbines in the more elevated upland areas, well separated from windy edge end wind farm, and where topographical containment reduces intervisibility. However, the steepness of landforms may restrict the potential for successfully accommodating larger groups and for turbines over 120 metres. Particular consideration must also be given to the setting of Hermitage Castle. Just in terms of topographical containment, reducing intervisibility, how do you interpret that? What sort of features do you think that's getting at?
Well, given that, I would expect, topographical containment is the topography that would help to screen the development from sensitive receptors. So
what valley is that? What valley sides or uplands, or how?
Well, in the context of southern uplands, I would have expected I would expect a scheme probably to be situated where it wouldn't be visible from the most sensitive receptors.
Yeah, so it would be on the uplands, wouldn't it? That'd be on the higher parts.
Yeah.
Yeah. So on the higher parts, drawn back sufficiently from the valley edge, so far as you can. That type of containment would be a sensible reading of that, wouldn't it?
That would be, yeah, I think that would be fair enough. And obviously, given particular site-specific considerations as well, it wouldn't.
Of course.
Be
and you'll have heard the evidence from Mr. Welch in relation to design philosophy, and I'm not going to go to his figure, but there's a figure which shows very clearly the ridges and the upland area and how turbines have been sited on that. And whether or not the reporter thinks, or you think, that the turbines have been successfully drawn back from the valley edges, that can we agree has been the design philosophy for the scheme. So to take into account that topographical containment, to focus on views and the valleys and out of that, and to put the turbines up above, that's been a design aim, hasn't it?
I think that's what Mr. Welch suggested.
Yeah. Do you agree with that, though? Do you agree in the
Well,
written?
I'm not convinced that in practice and in this particular scheme, the turbines that are in Scottish Borders actually reflect that. As I've said at a couple of occasions, the appearance of I think it's probably fair to say about 6 turbines appear to be stepping down off the upland hills into the Teviot and Limey Cleuch valleys, and yeah.
I mean,
In the instance on the north side of the scheme, I don't think that has necessarily been as effective.
Okay, 2 points there. One, I wasn't expecting you to say that yes, that's all been done successfully. That's the difference between us. The question really was, do you accept that, as explained by Mr. Welch, was in the design rationale? So it was taking into account that topographical containment point. The degree to which that was successful or not is a matter for the reporter. Mm-hmm. But do you at least agree that was written, that was embedded in the scheme? Yeah.
I'm satisfied with Mr. Welch's suggestion that was his design philosophy.
Yeah, rationale.
Yeah.
Thank you very much. That's helpful. Over to the next LCT then. That's the Southern Uplands Forest Covered LCT 5 Roman 1 Crike. So that's just below. So just doing the same exercise, landscape character sensitivity medium, visual sensitivity, low medium, landscape sensitivity low medium, landscape value medium high. Underlying landscape capacity confirmed for all the 5 turbine topologies. You've got low capacity then for the 120 plus. Yeah.
Yeah.
Proposed limits to future development confirmed for all 5 turbines. Low remaining landscape capacity for 120 plus. Same thing. Mm-hmm. And same thing. Maximum number of turbines 5 to 10. And in this case, the development. I mean, here your point about separation, and we can make submissions on that. The development's got 5 turbines, I think, in this LCT.
That's correct.
Uh-huh. So to the extent that fits, doesn't it, in terms of maximum numbers of the group, leaving other things aside, that's within that range.
By your interpretation of that, that would be your view. I would, I'm looking at the scheme as a whole, and certainly the scheme towards the, in the Scottish Borders area.
As I said, I was leaving aside that separation point, just in terms of maximum numbers in the group. 5 is clearly in the range 5 to 10, isn't it? And that was a simple point. Yeah.
There are 5 turbines in the Crake upland, Southern Uplands.
Yeah. Okay. That's helpful. Landscape analysis then in the 4th column. LCA extensive area rolling hill landform, steep-sided valleys, cloaked with commercial coniferous forestry, no designations or long distance footpaths, little human settlement, although the Southern Uplands Way passes along the northwestern edge. Area has low internal intervisibility, although the edges are visible from surrounding hill areas. And then development capacity contains no landscape designations, low internal intervisibility, sparsely populated area of the borders. Due to these factors, there is capacity for groups of larger turbines. Forest removal should be mitigated, preferably through compensatory planting. larger turbines can be accommodated in the larger scale elevated upland areas to take advantage of the topographical containment created by the landscape and screening by trees. Presence of the Southern Upland Way reduces capacity in the western parts of the LCA. So a similar write-up, but you've got mention there of the tree planting and the fact that that screening helps topographical containments. That's the slightly different wording, isn't it, to the for Roman 3?
That is that is the different wording.
In terms of both, so significant non-landscape constraints, we've got in bold text, haven't we? The eastern half of the LCA lies within the Eskdale-Muir EKA seismological area, 10 kilometres exclusion zone, the rest in the statutory safeguard area. We can see that actually is in bold and for 4 Roman 3 as well, can't we?
Yeah.
As a non-landscape constraint. So just taking all of that together, I think, well, I hope this is agreed, that a clear objective of the guidance in that more detailed assistance that you get from capacity study table 6.1 is to envisage further wind farm development within LCTs 4.3 and 5.1. That's what's seen as coming, isn't it? And is embedded in the table.
Based on that would be appear to be embedded in the table or is embedded in the table, because it clearly says there is low capacity, but there's a lot more considerations than just that simple statement that there is low capacity there. There is at the point when we receive the application, we then look at it, and there's clearly some provisos in that the development capacity in the called Kluke-Head group. They talk about elevated, well separated, and where topographical containment reduces intervisibility, steepness of the landform may restrict the potential for successfully accommodating larger groups. So there is considerations that have to be taken when choosing a site.
Of course, that's right.
And it follows down in the one below, the crepe one, where we have got larger turbines can be accommodated in the larger scale elevated upland areas and take advantage of the topographical containment created by the landscape and screening by trees. So there is, again, in both of those, there is a comment to be taken into consideration about. So basically we have a strategic type document, but then we have to drill down into these particular areas and look at how well a scheme or whether a scheme can be accommodated, taking those sort of considerations into.
Absolutely, and we started this run of questions with the absolutely standard stuff from capacity studies. This is not site specific, it's not scheme specific, it's at a higher level, but we've also agreed that this is the roadmap. If you're looking for development opportunities where you might sensibly and intelligently look, then this tells you where to go. And if that change is envisaged, there is going to be an inevitable change in character, isn't there? Which is picked up in the third column in table 6.1 for both of the LCTs. So we can see in relation to LCT 4.3, you've got a change from uplands with wind turbines stroke no wind turbines to a western area uplands with wind turbines. And for LCT 5.1, you've got uplands with no wind turbines to uplands with wind turbines. You see that that change. So again, embedded into the capacity study is that shift in characterization, isn't it? It's what is expected to come along through the development plan and the consenting process.
Yeah, clearly the council are committed to producing spatial guidance, and that's what they have done.
Yeah, so it's not a case, is it, of, well, don't want no turbines and that's no capacity and it's absolutely no way. What those descriptions do is say or attempt to describe how a person's perception of the two areas can be expected to change in line with the development plan process and consenting. So in other words, if the system works properly, intelligently guided towards these are the areas of high capacity, 120 plus, people are going to see, or people are going to perceive, landscape change in that way, to move from uplands with no turbines to uplands with wind turbines. That is what is going to happen.
Not to some extent that could be mitigated by appropriately siting them in so that topographical containment is maximised.
Okay, that's the caveat, of course. It's got to be a successful scheme, and ultimately it's for the reporter to determine whether that design rationale that we've already agreed has been successfully executed, isn't it? That's really the point.
That's fair enough.
Okay, that's a very useful run through those through the capacity issues. So, and I want to turn to the second of the issues. Now, I don't know whether you want to take a mid-morning break before I turn to issue 2, or we can continue. I don't mind.
I think that'd be helpful. Can we just have a 10-minute break, come back at 11:25?
Thank you.
So Dermot, if you could keep your camera on, please. Okay, everyone back. Mr. Hardy, you've appeared back on my screen. Good. Just didn't
Thank you.
for a little while. Okay.
Right.
Do you want to carry on?
Yes. So the final matter, we had 3, we've done 2. Number 3, the visual effects of the proposed development on sensitive receptors using the minor road to common brae and the A7. So that's reason for objection number 2, isn't it? And the particularisation of that. That's right, isn't it?
Right,
From reason for objection 2, we're concentrating on, or the councillors decided to concentrate on sensitive receptors using the minor road to common brae and then the A7.
That's correct.
You do with this in your report, paragraph 5.3, section 5, and you get into the detail of it in 5.3. We don't. I'm not necessarily needing to go to the ZTVs. You've seen them. We've all seen them. Basic point: the ZTVs are showing theoretical visibility. Of course, it's not what you're going to see on the ground. Yep.
Yes, that's correct.
And examination of figure 6.8c. You deal with that in your 5.3. So when, I mean, the report has been on site already and going to go on a site visit tomorrow. So the ground truthing, that's sometimes used as a term, isn't it? That if you're looking at what you see in theory, what you see on the ground, that's going to become evident to the reporter going out with ZTVs and the various visual aids that she's got. But it's just a general caveat. Okay, your paragraph 5.3, you say from the south, there are long areas of visibility of the development from the A7 on approach to the Scottish borders. That, just look at, when you look at the ZTVs, that's theoretical visibility. And can we agree that it is of a small number of turbines, and where that does occur, it's oblique to the direction of travel? You're never looking head on, are you? At the, put shortly, there, you theoretically you're going to see a small number of turbines, and they're going to be off to the side.
When we talk about the A7 South, I mean, we are talking we're not necessarily talking about the A7 as it just goes past the site. We are talking about where this clearly the ZTV shows the absolutely greatest amount of visibility in Dumfries and Galloway coming up. Langham and even south of that. So there is clearly, you know, that was the tone of that particular remark. That was proviso, and that was that people are travelling up the A7 to get to Scottish borders, or indeed to go on up to Edinburgh and on the historic route, and clearly there is visibility approaching from the south.
You've obviously driven the A7 a number of times. I mean, numerous times, sure. Yeah. And particularly that section from Langham to Teviot Head. Can we agree that where visibility would occur, or theoretically would occur at least, the applicant has tried to pick that up in representative viewpoints, and the viewpoints which have been agreed. So in other words, where you are going to get those views and the things that the sort of visibility you described, the applicant has done what it can to provide visual representations of that for the decision maker.
And I'm assuming that's exactly what he's done. There's been a selection of viewpoints. We didn't comment on the ones in Dumfries and Galloway. We would have restricted ourselves to commenting on, or having input on viewpoints in Scottish borders. So I can't necessarily confirm what the reasoning or the was behind choosing particular viewpoints in D&G.
I mean, Mr. Welch's evidence is quite clear about the intermittency of views, and what the applicant says is that it's only at the representative viewpoints that you will get sight of the turbines. And you're not suggesting, are you, that there are other viewpoints which should have been taken, which from which you would get the sort of visibility you're talking about? We are dealing with the viewpoints which have been chosen, which will give visibility so far as it is. Your view is simply that is an unacceptable imposition as a judgment, as opposed to the view of Mr. Welch. Is that? We're not talking about missing analysis, is really what I'm getting at. You're not saying that we've missed or not pointed out where you're going to get visibility on the A7.
No, I'm not pointing out that you.
Thank you.
No, and we did get. After the application there was a subsequent viewpoint on the A7. The first one on the A7 in Scottish Borders Council was submitted as supplementary information. So there clearly was, based on I think our early discussions, that there was a realisation by the applicant that the A7 in Scottish Borders hadn't been represented by a viewpoint. So was agreed. I think it was agreed, but certainly the one at Teviot Head was chosen.
And you've seen the wire lines, no doubt. You've seen the wire lines that support the RVA, the application. Presumably, you've also seen the residential visual assessment wire lines. Have you? There, I think, chapter 6 of the EIAR.
Yes, I've read through the whole of that chapter.
And what you see. And this will be a matter ultimately for site visit, that those long areas of visibility are to a very large extent screened by vegetation, aren't they? So the difference, the ground truthing, the difference between what you see or what would be theoretically visible and what you see on the ground is to a very large extent dictated by vegetation.
That would appear to be the case, and that'll clearly it'll be useful having the site visit tomorrow. I think most of the viewpoint, the site viewpoints we're visiting tomorrow will be, located in Dumfries and Galloway.
There are some other features. Obviously, the reporter will have seen those, but there is the 132 kV pylon strung transmission line, isn't there? That runs alongside the length of the journey as you approach the borders.
Yeah,
that's quite an unusual feature.
Not sure you'd call it unusual. I think everybody is fairly habituated to turbines and pylons. Sorry, pylons, not turbines, I say.
It's interesting as a Freudian slip, maybe.
Yes,
habituated to turbines and pylons, but I've got it. I mean, habituation is an important concept, isn't it, actually? People become habituated to pylons, people become habituated to turbines too, don't they?
Is that a question, or is that a discussion?
No, it's a question based on what I might say is a Freudian slip. People do become habituated, don't they, to turbines?
I certainly think that's is the case to some extent. Yeah, I don't want to quantify that, but it may be that they become habituated to ones that have been deemed to be in suitable locations.
All right. I'll leave that there. Do you accept, just a relative point, do you accept that the wind farm will be relatively more prominent leaving the borders on the A7 in terms of north-south? Do you have a view on that? So you might want to go to the viewpoint 26. I think that's the one south of TV ahead if you want to. If you want to guide, have you formed any view on north or south, or?
I mean, I basically restricted my comments to viewpoints in Scottish borders. So on A7, we have only got the one at TV head, and clearly, you know, it's quite prominent up that side valley.
All right, well, I'll leave that there. 5.4 of your report, viewpoint 10. That's the Hizzy Cairn.
That's correct.
And what you say is that in your 5.4, it's evident that turbines 1, 3, 4, and 6 occupy lower AOD levels as they noticeably step down from the elevated upland platform towards the incised valley. Excessive scale appears significantly out of keeping. That is part, isn't it? The area in which turbines 1, 3, 4, and 6 are located is within that LCT 4-3. So that's the southern uplands with the scattered forest coal Clwch head group.
That's
LCT.
Correct.
Yeah. And the capacity study, been through this, but it tells us that the council envisaged the area shown in the baseline photograph of viewpoint 10 for Hizzy Cairn as including viewpoint 10 itself as becoming a landscape with wind turbines typology. Do you recall those questions at the end of the capacity study about what was embedded in the tables? So the capacity study itself is seeing the area including viewpoint 10, Hizzy Cairn, as becoming a landscape with wind turbines should the process work, doesn't it?
I think that's an oversimplification of the capacity study. It's much more nuanced than that, and it does have all the provisos, or whatever you want to call them, you know, considerations that need to be taken into consideration, including, and I'm repeating it, topographical containment, and clearly that would be where I would, you know, having looked at a site-specific development, I'm not sure that it fits with those that guidance.
Well, the point remains, doesn't it, that the area that's shown in the baseline photograph of viewpoint 10, so that's the view from Hizzy Cairn, which includes viewpoint 10 and things which are shown on that. If things work according to the development plan and capacity study, that is being envisaged as a landscape which will move from one without turbines to a landscape with turbines topology. So in other words, you're going to see turbines. That's what's embedded in that study process, isn't it?
Are you saying in as much as some of the figures or the narrative that goes with it? I mean, are you saying is that per se for the called Clúchhead group, or is it particularly relating to some of the figures 6?
What I'm saying is LCT 4.3, Southern Uplands of the Scattered Forest Coal Clúchhead group. When you look at the table, you look at the locational guide, the table 6.1 that we went through in detail. There's a move, isn't there, from a landscape without turbines to a landscape with wind turbines. That's what's expected.
Doesn't mean that they should necessarily come down into the valley.
No, and there are points about topographical containment, and of course that will be, that's for debate. But the principle of change, I suppose, so the perception of the landscape is going to move, isn't it, from one without turbines to one, well, you are going to have that view, but you are going to see turbines to some extent in it. That is what the output from the capacity study exercise is.
I suppose that it's offering potential for wind farms, what it is, but clearly there's greater considerations than just that. That's a starting point, I guess.
Yes, of course. But potential, it's not there for fun, is it? It's not there just to tick a box to say we've got a capacity study. The way the development plan process works is, you go to the policy says you've got to look at the capacity study. The capacity study tells you we've agreed this is an intelligent place to start. You do all of that. And with the capacity that's there, it says there's changes are coming. If things work, in the way that we suggest that they ought to, turbines are coming, and there will be a change to a topology of landscape with wind turbines. That will include all of the area that's shown in that baseline photograph from viewpoint 10.
I'm not convinced it's as straightforward as that. I feel there is an argument to be said that they should not be coming down into the valleys, and that the southern uplands, so it's potential. There's potential for turbines on the more elevated,
on the higher ground.
Yes. So I don't think we'll, I'm clear in my mind that view from Hizzy Cairn is the turbines appear to be dropping down quite significantly from some of the other heights.
Okay, so the difference between us is that the success or otherwise goes back, doesn't it, to that design rationale. And Mr. Welsh says that he's done that successfully, and on the high ground you're saying that yes, you accept the point in general, but from this location you think that the keeping the turbines off the high ground is less successful.
I think that's fair summation.
And there is there's agreement, isn't there? If you look at the assessment from Mr. Welsh, that there will be significant effects in visual terms. We're not shying away from that. It's the acceptability of those is a matter for the reporter. Okay.
I think in my initial responses, I was very clear about acknowledging and where the LVIA had identified significance. So yes, I don't think we're in any dispute about that.
Okay. Minor road to common break. Well, no, before we go there, I think it's just a final point coming out of that you say the siting of turbines, 200-metre turbines out with the more elevated parts of the Southern Uplands conflicts with guidance within the Ironside-Farrar study. What you mean by that is what we've just clarified, the extent to which they fall out of that topographical containment. Is that's your point? The way. The reason that they've conflict with the guidance is not. It's not their presence within the LCT or general capacity points. It's the specific point. You say that they come off that higher ground and therefore are not topographically contained in the way that you feel they ought to be. Is that the conflict?
And I suppose I'm obviously commenting on 13 turbines, within Scottish borders. So yes, I'm looking at those specifically. So yes, that would be my concerns in relation to those,
in a nutshell.
particular turbines.
So,
yes.
I mean, just turning that round, if the turbines 1, 3, 4, and 6 were removed, just theoretically were removed, presumably that then falls away, because those are the concern. If you then want to, those are the ones noticeably stepping down. If you take the ones which are noticeably stepping down based on everything we've looked at, presumably that would make you change your position.
And I would probably go ahead, include 2 and 5 as being of the ones that are stepping down, because there is recognised, and I'm just trying to think, all of those bar number 5 are below that 370 AOD. So they are the 6 lowest turbines within Scottish borders. It wouldn't. I can't assume that all my objections wouldn't go away by removing those 6. It would certainly improve the situation greatly, and I would have to then judge it based on what was left and the scheme that was. If there was an amended scheme, I would have to judge that. I suppose is what I'm trying to say.
Yeah. And it's only a thumbnail. It's not something that's on the applicant is proposing. But I just, I'm satisfied with that. Improve the situation greatly, but you need to look at it and whether or not at that stage it would assuage your concerns completely. That's fine. So minor road to common. So the minor road to common Bray, I think we probably dealt with that. Apart from the residential amenity of the properties, you're not taking a particular point, are you, in relation to houses? It's not you're not taking a point that Mr. Campbell's clients take in relation to overwhelming or overbearing of properties?
No, I'm not. On the basis that there's a balance to be struck, and I suppose from my experience, there isn't necessarily a reason for objection on that count from my perspective, which would be clearly different from residents. Yeah,
no, that's absolutely fine. It's very clear. Let me just check my notes. McDermott. Yeah, just a point to pick up from your recognition, if we may. Paragraph 4.1.
Do you want me to go to the recognition?
Yes, please, if you can. Yeah, just to
can you give me the core document number then? Apologies. Not. Maybe it isn't a core document.
The answer is I've got a hard copy. I don't know. It's not a core document, I'm told.
You want to read out?
Should I read out? If you want to find it. All right. Paragraph 4.1. What it says, the intermittent visibility from the A7 approaching the wind farm from north and south. Within Scottish borders, only one viewpoint on A7 is provided. That's viewpoint 1. And it demonstrates how the turbines will be seen up the side valley. I suggest this view is representative of other intermittent views from stretches of the A7 further north as the road runs southward up the Teviot Valley, and in many places concentrating views towards the wind farm in the hills to the south. It was a curious comment, really. You can't use viewpoints, can you, as surrogates for different locations several kilometres away. You've got to take the viewpoints as they are.
Absolutely, and I couldn't agree more. However, we did have very limited viewpoints on the A7 in Scottish Borders Council, and I suppose the point I was making was trying to make, you know, and clearly the Teviot Head viewpoint is probably the closest one to the northern part of the scheme in Scottish Borders.
Yeah.
There are, you know, there are other places where you further north where you do get sight of those hills, and I suppose it a viewpoint is only a viewpoint. It's one place from where, in a way, it shouldn't dismiss the fact that there are other there is visibility elsewhere. I mean, we clearly can't have such a range of viewpoints that there's you know, be untenable. But yeah, that would be.
No, it was really the surrogacy point, because you make it again. I asked questions very early on about the field work that had been done, and you answered that question. But elsewhere in paragraph 4.1, you say this: whilst I acknowledge the wind farm has more limited potential visibility from Borders, for 6 of the 8 viewpoints within Borders, the visual effects are deemed to be significant. And then you say this: I suggest that within 15 kilometres of the wind farm, it's highly likely that areas with visibility of the wind farm will experience similar significant visual effects. Again, that's a very generalised point. You can't extrapolate, can you, from tell you what you've got to do. And there's a sufficiency of information here to look precisely at where viewpoints are chosen to assess those. Yes, you have to draw broader conclusions. You're not looking at snapshots, but it's not acceptable to guess, is it? It's not acceptable to extrapolate and guess from one viewpoint.
No, I don't think it was a guess. It probably was a suggestion, but possibly, if inappropriate, then I absolutely apologise for that. But I suppose the point I'm making, it isn't just from the roads; it's from elevated sides of the valleys, residential areas up, you know, north. There is potential visibility of the scheme.
Yeah, it's perhaps deficiency in wording.
It's making a general comment, probably.
Yeah, it's deficiency in wording. Mr. McDermott, nothing more than that.
Absolutely.
I'm not suggesting you being unprofessional. All right, that's helpful to me. Thank you very much for your responses.
Thank you. Thank you, Ma'am.
Thank you, Mr. Hardy. I just have a question for you, Ms. McDermott, and it's coming back to this issue of aviation lighting. And in your report, at paragraph 6.7, I think you acknowledge here that aviation lighting is something which is something relatively new in this field of work. I wanted to understand what do you think the purpose of aviation lighting is? What would you say the purpose of it is?
I understood it was for safety, aviation safety.
So what does that translate into? What's required as a result of that?
I guess it's an agreement from the CAA that the lighting is adequate to deal with any issues relating to overfly of the area.
So could you tell me what your outstanding concerns are then with regard to aviation lighting? In summary.
My main concern, I suppose, is that we are changing the nighttime character of the landscape we are talking about a fairly remote area, low population, and for the introduction of lighting into an area like that, we definitely changed the landscape, the nighttime landscape character of the area, and I think that could be to the detriment of the landscape.
Is this from particular locations?
Not particularly, no. I mean, it's just through location, people travelling through the borders, minor roads, the more A roads, residents. It's this introduction of another feature into the landscape at night, when there is certainly not very far south, there is a dark sky sort of, clearly that is desirable, because there are now dark sky areas. When I'm not saying we're in that, but the introduction of lighting does introduce another element into a scheme, which kind of highlights the fact that there is development there.
From your evidence, in reading it, I just got the feeling that you had seen many examples, or any examples you can maybe tell me of other schemes elsewhere, lighting schemes elsewhere, just to give that insight into your knowledge and understanding of what they can actually look like when on the ground. Have you had the opportunity? Is that still the case, or have you had the opportunity to see?
It absolutely is still the case. Nature Scott did about, well, it'll have been before COVID, so 3 years plus had a site visit. Unfortunately, they were heavily subscribed and didn't have enough people, so they did a look at aviation lighting, I think concentrating around the Glasgow area and south, so that there was a sort of and I wasn't, and unfortunately wasn't able to do that.
And are there any in Scottish Borders area?
No, there is clearly going to be at Crystal Rig 4, but no, not to date. And that in itself may be a reason for our concerns, or a part of the reason for our concern is that we are, it's clearly an issue that we're trying to take on board and establish best method of mitigation.
Thank you. Just looking at one more question really about viewpoints that have been provided as part of the environmental impact assessment. And you make some comments regarding, I suppose, the more distant viewpoints. Just 1 second. So you talk about viewpoint 20 at Greatmore Hill, and you talk about viewpoint 24 at Rubers Hill, and also viewpoint 19. These are all viewpoints that have been provided as part of the application. Can I just be clear? Are you concerned, particularly Greatmore Hill and Rubers Law? I think you describe a bit more detail in terms of viewpoint 19. Are they concerns for Scottish Borders Council? And is it from both a landscape impact, visual impact, and is it also from a lighting aspect as well? Could you explain what the nature of your concerns are there? Because there's not a great amount of detail on those two.
No, I suppose in terms of Rubers Law, and I think I probably might concentrate on that. It is a very popular hill for people to go up. So there is this, I suppose you could call it iconic status for Rubers Law. It's a heavily visited viewpoint for hills, should I say, and while it is 25 kilometres distant from the scheme, I was surprised at just when we got the updated photo montage and baseline photography. I was, clearly the turbines are quite visible in the in that section of the view, and have an awkward juxtaposition with some of the Skelfield Pen, for example, where they pop up on both sides of this smaller but quite dramatic cone-shaped hill. And at the northern end, the turbines are particularly prominent, skylined as they are. So that was my concern.
I suppose I'm just trying to go back to Scottish Borders' original objection. Objection 1 deals with landscape character, objection 2 deals with visual impact, and it very specifically refers to sensitive receptors using the minor road to Common Brae travelling to and from the Scottish Borders, and then objection 3 is dealing with aviation lighting. And I agree, it talks about even visible from a considerable distance. So you're saying for Rupert's Law, the example you just talked about, it's the visual impact, not just lighting, it's visual impact generally.
I have concerns about it. I don't know if we were eliminating all the other concerns I have, whether we would be objecting on Rupert's Law, but it is quite an important viewpoint. And when I say I don't know if we'd be objecting, I don't know if we'd have, there would be enough to object on, given I can't imagine that there's very many objections on viewpoint 25 kilometres away, but it does demonstrate, I think, that there are I consider significant visual impacts from Rupert's Law. Clearly, not sure the aviation lighting is going to be a major factor in that, because I think the idea that we would that Rupert's Law people might be travelling up there overnight at night time, albeit they could be doing it at dusk or dawn. Well, dusk at dawn, but I can't. May be wrong, but it's not going to be a huge number of people up Rupert's Law in the middle of the night.
Okay, I think I understand your position. And is that the same position you reach with regard to Great Moor Hill as well? Yeah, see. Back in your report.
Back in I think Great Moor Hill demonstrates just the spread and possibly the visual intrusion of the scheme from that viewpoint.
Okay. Similar position in that probably Scottish Borders haven't objected to that particular more distant aspect. Thank you, Ms. McDermott. Mr. Kirk, do you have any re-examination questions for your witness?
No, ma'am, nothing rising. Thank you.
Okay. Thank you, Ms. McDermott. That's you.
Thank you.
Okay, I propose we stop for lunch, which is just gone 12 o'clock, so we can back here at 1 p.m. Thank you. Okay, just waiting for everyone to join the call. Apologies for calling you Ken this morning.
Oh, not at all. I was
You know.
I was down in the hotel as Keith, so it seems to be a bit of a theme this week.
Are we expecting Mr. Hardy to join us?
Okay.
There he is. Just by magic. Okay. I think that's everybody. Mr. John Campbell, you've got Yvonne Jackson with you as well, potentially to speak.
She's online, yes.
She's online.
I don't see her yet, but I know that she's coming up at 4 o'clock. Oh,
There she is. Right, that's good. If we could just have everybody on the screen, if that's manageable, that's fine. That's seven pictures of people, and just checking everybody should be there. Yeah. Okay. Right. Okay. If we could make a start. Well, welcome back. This is a session that was originally arranged for today, and we've managed to bring it in today, which is great. We're not going to be covering any matters that concern the MOD's objections in relation to conditions. And there are, as we touch on them, I'll skip over those as we go through each of the conditions. I think we'll work through them in turn, if that's all right with you. That makes the most sense. I've got the comments that have been provided from all the parties here, and we will work through them this is a roundtable discussion, a hearing session. So we'll just try and keep it fairly organised. And if you want to speak, raise your hand if you want to add a comment or say anything as we go before we move on to the next condition. So we'll do it that way, if that's okay. So first of all, if we're looking at the section 36 consent conditions, we have a list of 6 conditions that have been suggested. So starting off with duration of consent, I'm just going to skip over those where there's consensus, if that's all right. So number 1, duration of consent. There's no disagreements there on that particular one. Number 2 deals with commencement of development, and Dumfries and Galloway Council are suggesting that this should be shortened to 3 years from the stated 5 years. Could someone from Dumfries and Galloway Council just explain why you think 3 years is more appropriate?
Yes, ma'am. If I start and then hand over to Mr. McTeer, I mean, our point here is obviously it's consistent with the Town and Country Planning Scotland Act, Section 58, the Scottish Government's support for the implementation of permissions in a reasonable period. And obviously that's recognised in the 1997 Act as 3 years. And it's really for a party to justify a later period, we would suggest. And if I just pass over to Mr. Tier on that.
The only other thing that I would add to that is the Hoff model conditions.
Mr. McTeer, sorry to interrupt you. You're very muffled. I can't hear you properly. Could you try that again?
Hello? How's that?
Still very muffled. Sorry. I don't know if it's your microphone or what it is. Could you just have a look at your settings? Is anybody else finding that very muffled?
Yes.
Not just me. Mr. McTeer? No, no better. Are you in the same office or are you in a separate office?
We are in the same room, yes.
Oh, okay.
Okay, I've tried a different setting there. How does that one sound?
Perfect. Really good.
Okay.
Yeah, you can just put your camera back on. That'd be great. Yeah, that.
I knocked it off the top of my laptop, so I had to redo that one as well.
Okay.
So, where was I? Yeah, the HOPS model conditions that we're using, condition number 2 does suggest 3 years for a Section 36 consent. So we were I mean, we appreciate that some developments may take longer to come on stream than others, but we still think 3 years is a reasonable amount of time to do that. But realising that is for yourself, ma'am.
Mr. Hardy, do you want to comment, or Mr. Campbell?
Mr. Campbell, I don't mind.
By the way,
Either way, okay. So just usual thing with it's a large wind farm, number of conditions to discharge, usual range of the matters which need to be dealt with. Just experience tells you that the longer period is fair, reasonable, and justified. Obviously, if it can be done sooner, it will. But it's to prevent having to come back, expiry, extensions, and all of that.
Okay. Thank you. Next, condition number 3, there's nothing to dispute there. So I'll move on from that. Next one, for serious incident reporting. There's a suggestion here by Dumfries and Galloway and by Foresight Community Group that it's also notified to planning authorities, both planning authorities, I think, as part of this. The applicant does not agree with that and points me to model condition number 4.
Yeah.
Can I just ask either Dumfries and Galloway Council maybe first just explain why that should include planning authorities? What's the reason for that?
Well, Mum, again, would suggest that it's in the public interest that that the planning authority is informed in relation to serious incidents. And again, I'll pass over to Mr. McTeer on that.
Is it normal practice for planning authorities to be included in that notification? I can have a look at some recent decisions.
I think our feeling is that the potential for, and you know, it's one of these things where we hope that there are no serious incidents, you know, when during construction or operation, but it has the potential to impact on other services within the council. So it's not necessarily the planning authority per se, but it's as an arm of the council. You know, if any of our colleagues in, you know, environmental health, for instance, needed to be, or roads needed to be involved, you know, with that, then we think it's just a bit more control over that. But again, and I'll probably say this quite a lot, it is a matter for yourself.
Okay. Mr. John Campbell, anything to add?
Yes, ma'am. There are three things here in my submission. The first is that the Scottish Government is relatively remote from the actual development, and therefore, like a large dinosaur, if you tweak its tail, it takes a little while to react. It doesn't have, in other words, direct on-the-ground health and safety responsibilities. It would have to devolve those to the HSE, which itself is a national body, and although they can react quickly, there is the disadvantage that being a national body, that they may not be able to react as quickly as a local body. You will notice, the second thing is, you'll notice that in the second line of this draft condition, the words environmental obligations appear. Now, whilst Dumfries and Galloway Council and or Scottish Borders Council may not have direct health and safety responsibilities other than the normal, they certainly do have environmental responsibilities, not only through Mr. McTeer's department, but also, for example, environmental health and enforcement questions. And therefore, to be able to react properly, let's say to a peat slide or a flood or something of that nature, it would in our submission be appropriate to have the planning authorities notified as well. The third thing is this, the draft condition is headed serious incident reporting, but in its first line, it just says any breach of health and safety or environmental obligations. Now, it's appropriate in my submission in a draft for some distinction to be made between serious incidents and trivial incidents. If somebody spills a can of diesel, that's not a serious incident, although it may be unpleasant very locally, for example, causing minor pollution in the watercourse. On the other hand, you can figure the sort of incident that might be very serious indeed. And so without suggesting and drafting on the hoof in my submission, there should be some distinction made between serious incidents and trivial. Miss Jackson is a chartered engineer. Miss Jackson is a chartered engineer, and I think with experience on site, so she may have something to add to that. I don't know.
Ms. Jackson, anything to add?
I haven't got anything specific to add to what John Campbell has suggested here, only that it's a possibility for trending patterns if there are issues relating to HSE on site over a long period. It's important that there isn't a problem with issues and there are no lessons learned as a result of these issues being experienced in repetition. So it's generally considered good practice that these are dealt with, and there's a notification of how the lesson has been learned and that problem won't be repeated.
Okay. The applicant?
The applicant would note, I mean, it is the HOPS model condition that has been used there. I think our view is, regarding what Mr. Campbell was saying about the drafting of the condition, I think there could be difficulties in defining what is or is not a serious incident in a variety of scenarios, and indeed would presumably put the onus on somebody at the developer end to make that decision, which may not be what the authorities particularly wanted. As regards inclusion of the planning authorities, we simply noted they are not included in the HOPS model condition, but it is not something I think that the applicant feels strongly about. And if the reporter felt it was appropriate to include notification of the planning authorities, then that would not give cause for concern.
Thank you.
With great respect, ma'am, the condition fails if it's not precise. If that's not self-evident, it shouldn't be beyond the wit of Cameron McKenna to draft a supplementary condition or a subordinate condition defining serious incidents.
I think the condition is precise. It requires that any breach is notified.
Okay, noted. Thank you. The next condition deals with NAT's en route concerns around aviation radar. Now, I think we could probably talk about this appropriately now. So the the suggestion from Dumfries and Galloway, and this reflects the next conditions that follow, is that whether these should actually be deemed to consent conditions rather than Section 36 conditions. The response from the applicant, and I think Foresight Community Group agrees with that, the response from the applicant is following model condition 5, where I note that it does have aviation radar as one of the Section 36 consent conditions. So can I just understand Dumfries and Galloway's general point here about some of these more, what they call more technical conditions, being more appropriate for deemed consent, and what the advantages and disadvantages of them being in this part of the consenting process?
Yes, ma'am. I mean, obviously, we're not arguing for the non-inclusion. We just feel that any issues that might arise from that, if they were part of the deemed planning permission, could just be dealt with quicker and more effectively by the council. Mr. Campbell did point out that sometimes the Scottish ministers are a bit remote sometimes when looking at this type of thing. So we just feel that it would allow us a bit more control over any issues that may arise with that, just in terms of discharging the conditions.
The main party to be notified, well, this has arisen as a result of Nat's interest in this. We can ask the applicant to come in now. Is there anything you want to say in response to that?
I don't think we've anything, ma'am, to add to our comments. It is, again, in accordance with the HOP model condition. It obviously relates to NATS radar and national radar coverage, and the applicant's view is it is appropriate for that to be in the Section 36 consent.
Any further comments on that particular one? Mr. Campbell.
Ma'am, for what it's worth, that's consistent with experience, what my friend Mr. Keith Campbell has just said. I do wonder, but it's only a rhetorical question, whether Dumfries and Galloway Council has within its skill set the ability to assess a primary radar mitigation scheme, or whether that isn't something that can really only be done by specialists. I don't intend any pejorative reference by that, Mr. McTeer, so please don't take it that way. But it is a matter of immense scientific complexity, which NATS and the CAA are capable of sorting out or understanding, but local authorities may not be. Of course, I may be quite wrong.
Okay, thank you. I'm going to skip over condition 6, which directly relates to the Ministry of Defence's concerns. And if that's okay, that makes sense. And move on to aviation lighting, condition 7. I've looked into this a little bit more. Again, the point made by Dumfries and Galloway, this is more of a technical condition that be expressed as part of deemed permission. I was looking at examples recently of decisions that have been taken by Scottish ministers. And I've got a few examples here of the way in which aviation lighting is being handled by Scottish ministers when this arrives at their door. Recent examples where this has actually been placed into as a deemed consent rather than Section 36 is Strathy Wood, I think it's Arclere, which is in South Ayrshire, and Blairgar, which is in Argyll and Bute. All three of those consents, which are fairly recent decisions, have placed that particular condition into deemed consent. I think the difference was in relation to Crystal Rig 4, where it dealt with military aviation lighting, and in that particular case, it was dealt with as Section 36. But the standard aviation lighting that falls under Civil Aviation Authority's approval process, that was in as a deemed consent condition, so it's separated out. So just to give you that bit of background, can I hear from Dumfries and Galloway Council first about what issues there are there for you?
Again, it's just picking up on the technical nature of that. We would, if there were any changes, then having it as part of the deemed permission just allows us to respond to that quicker than coming in from the ministers.
The Scottish Borders, Mr. Shearer.
Good afternoon. Yeah, just in agreement with our colleagues in Dumfries, feel it sits more comfortably in the deemed permission. We'd also expect, I suppose, if for whatever reason, if the consented lights or one of the consented lights stops working, that's likely to be noted by people in the local community who are more than likely come to the council in the first instance. I would imagine. So yeah, we would maintain it be a bit more easier to be handled if it was part of the deemed consent.
Scottish Borders Council have raised some questions around whether the scheme that's been put forward has been approved by Civil Aviation Authority. So I think there's references to the documentation for the inquiry on that that you'll see. Are you happy that that's now covered?
Yes, yeah, absolutely. Yeah, no, we're pleased to see that. Yeah, so thank you for that.
And you'll know that infrared lighting is something that's been raised through a number of parties that's consideration for this inquiry. Okay, can I ask Mr. Campbell, do you have anything to add to that?
We don't.
Oh, sorry, Mr. John Campbell first. Sorry, I'll be clear, Mr. John Campbell. He's shaking his
Apologies.
head. No, Mr. Keith Campbell.
No, thank you. No, thank you. We don't.
Okay. Nothing further. Okay, thank you.
Not on number 7.
Right. Moving on to deemed consent conditions. So we're now into number 8. Excuse me, my eyesight's not doing too well here. So this is to do with in accordance with the plans and requirements. And there's a reference here from Dumfries and Galloway that this should actually say the application documentation rather than just the application. And I think Foresight Community Group have got a comment here, just a question, just 2 lines in addition, which we're not sure what they mean. So first of all, I'll just ask Foresight Community Group, can you just clarify what you mean by in addition in your comment there?
I didn't write it, but I think it means the same as Dumfries and Galloway. That it should be application documentation. If Miss Jackson's nodding, then you can take it that that's correct.
Sorry, can you say that again? Sorry, it means what? Sorry.
It means the same as, I think it's meant to mean the same as Dumfries and Galloway want to see, which is the use of the words application documentation.
Probably amend the.
Although application is a defined term in the schedule of conditions. And if we go back to the beginning,
Yes. Yeah.
and we go back to the first page, application is defined as the application submitted by the company. The trouble is that it doesn't always happen in one step. An application, as you know, can be amended and altered as matters go forward. The environmental information is very often changed. Tiny details, microsighting, all of that. So perhaps this, with respect to Cameron McKenna, perhaps this definition in the glossary isn't quite good enough and it needs to be tightened. But the principle is clear, which is that what is built accords with the application as it finally emerges from the examination process. I suppose you might consider that in writing your report for ministers, you make space to define what the application is in your mind, having heard all the evidence.
Does the applicant want to come in on that?
Yeah, I think we would entirely agree with that. I don't think there's any significant point of principle between any of the parties here, but I would entirely agree with Mr. Campbell. I think application is defined as the application as submitted in May 2019, and that may need amendment to reflect, as Mr. Campbell said, that there has been obviously additional information submitted after that, and to make sure that that reflected the application as in its ultimate form.
Okay, so there might be some way to, would that meet the concerns of Dumfries and Galloway Council, or were your concerns slightly different to what's being suggested there?
No, ma'am, that fits in with our concerns as well. So I think I think all the parties are at one on that.
Okay.
Yeah. So
On to number 9, which is to do with the design and operation of the turbines. So there's a change suggested by Dumfries and Galloway. Just want to ask why you're suggesting that particular change to point 1 of that condition.
Ma'am, there has been a change to this, a slight amendment to this, the wording of this condition, and we're content with the wording that's now set out. So we don't have any issue with this condition now as set out.
So as written in the first column there, you're happy with that as written?
Yes, ma'am.
Okay. Remind you. British Borders have made a note about non-reflective pale grey colour, which I don't think the applicant is accepting. Just a second.
I think, ma'am, non-reflective pale grey is in there anyway.
It is.
Yeah, that's right. Yeah, we're happy with the suggested wording.
So I just spotted it. Sorry about that. Mr. John Campbell, you've got some comments. Anything left outstanding from your point of view?
Yes, ma'am. The group is of the view that the development should be shown to deliver what it says it's going to deliver once it's completed. So the drafting here, which may not be perfect, but it's good enough for the illustration of this point, is to suggest to you that it is reasonable to expect that the developer should evaluate the technical specifications for the turbines that he ultimately chooses and how those would operate with the wind speed data which has already been gathered. The wind farm developer in our submission should be able to provide the planning authority with the necessary information relating to the selected turbine design and selection once that is done. Now, it is known, ma'am, that the turbine manufacturers are able to provide technical details relating to each of the models they offer. This is public information easily obtained on the various data sources for the different manufacturers. In fact, over the years, we have seen greater and greater transparency about turbine performances. Now, why should this be necessary? Ma'am, this is a project on an enormous scale, and it bears to be a project which will make a substantial contribution to national targets and ultimately to the ambition of net zero. The public needs to know in our submission whether the development which is ultimately consented and built will do what it says on the tin, to misquote an advertisement, which we're all familiar with, to do what it says on the tin and make the contribution which has justified the granting of consent. So, ma'am, if you decide to recommend to ministers that this proposal as it's set out should be granted, and ministers agree with you, then there will ultimately be a capacity of X megawatts. By that stage, it's to be expected that a developer will have at least begun the procurement process for the turbines he wants to build. The market's not unlimited, but there is a market. And quite understandably, developers hold back from specifying the turbines they want to use because they will otherwise lose a competitive advantage in as between or as among the various suppliers. So the group's view is that the public need for transparency in this area is valid, particularly if public money is involved, and that the public needs to see that what is promised is being delivered in terms of performance and the delivery of electricity into the grid. This can be done on paper, before development commences, but after the selection of turbines is complete. It could also, in theory, be done after installation, although the sanction of removing turbines, of course, is probably a step too far, and it wouldn't be possible to remove them if it didn't come up to expectations. I hope that's clear. I'm happy to speak further on it if you wish.
Yeah, thank you.
I might just ask my colleague, Mr. Jackson, if she has anything to add to that.
Mr. Jackson?
I think you've explained it very well, John. I think what we're asking for here as a group is technical accountability for the design, in the sense that this is a large-scale energy project which is being proposed, and the public do deserve to know what the performance of the energy plant will be. It impacts on the discussions that we've been having over the last few weeks in terms of noise level output, power output, foundation size. All of these issues which are linked to the EIA discussions are also linked to the performance and the selection of the turbines. And it is not unfeasible to evaluate the turbines against these criteria and confirm that the final selection of turbines is actually delivering in line with the consented application. And I think it's only right in the way that the world is moving forward in terms of transparency with regard to renewable energy projects, that this type of information is part of the planning consent process.
Thank you. Applicant, would you want to come in? Mr. Hardy?
Yes, I'll just come in with that. I mean, we've seen action groups in various places put this or try and put a gloss on this sort of condition before, albeit I've not seen this particular type of gloss. 3 points really. One, you can't guarantee what's sometimes said. Look, there needs to be a minimum shop floor that's guaranteed, so that if it's not delivered at X megawatt, then you take the turbines down. That doesn't work for a number of reasons, but it's not, as I understand it, what's being asked for here. Second thing is, details are covered by 9.1. So no commencement of development unless full details of the proposed wind turbine. So that's including but not limited to size, type, external finish and colour. So if the council want to ask for technical data, then they can do that. They can do that, and if it's not supplied in writing, it won't get signed off. And then in terms of compliance, so that's dealt with by 9.2. So the turbines have got to be consistent with the turbine range assessed in the EIAR as amended or supplemented by the AEI. So you're getting what's been, it's got to be within the range of what's been assessed. And technical details you could ask for under 1 if the authority thought that was proportionate. So I've not heard anything which justifies a change to the proposed wording.
Mr. Jackson, you're coming.
Yes, I can hear what Mr. Hardy's saying in terms of the information that's listed there as size, type, external finish and colour, but I'm talking about the technical details relating to performance, such as the power curves, which are available from the suppliers. I think the wording as it's shown seems to be a very visual description and dimensional description of the turbine, which is of course required when you're evaluating it in this context, but I think it's not sufficient just to look at it from that perspective. You need to look at the way the turbine will perform in operation in terms of the power that's generated and the noise levels that we're creating. So I don't think it's quite sufficient as it's written.
That I think is a misreading of the condition, because the word including, but not limited to. So yes, you've got those visual matters, but full detail. So if the council were persuaded that they wanted technical data sheets or whatever it is, then they could get that. So there's nothing stopping the authority getting any of the information it wants, and it won't sign the turbine choice off unless it does that. But it would have to decide what it thought was proportionate and in the public interest to require. So I just think that whatever the concern is dealt with by the current wording.
Mr. Hardy, is this just something that you're not able to confirm at this point in time? So that level of detail is not possible to put into this condition.
You don't know the I mean, just simply because you don't know the you don't know the turbine. But if you so the particular performance characteristics of the turbine, you don't know because obviously you haven't chosen the turbine. If you're saying technical details, can they be provided? Yes, they could. They're not normally asked for, but the council it could if it was persuaded that it wanted technical data sheets of the sort that Ms Jackson's just indicated. They could obtain those under 9.1 because it's not restricted to visual matters. It's only a list, the usual things that councils ask for, but full details could include those. So the council would decide.
Sorry, Mr. Hardy, I was just suggesting as a public body, we're probably not going to be part of that process. So having this defined a little bit further at this stage would be helpful for our reassurance that those types of issues are taken into account. You're saying it's all feasible. I'm just asking the question as a member of the public that will be taken into account because it's a relevant part of the consenting process. So perhaps I just need reassurance here from those that are present in the discussion today that type of evaluation will be carried out.
Well, okay. I mean, I personally don't think it's necessary, and it would be up to the council to determine whether they agreed with that level of that level of specificity and technical detail was required. But the submission would remain the same. That's up to the councils, and they can require that under 9.1 or 9.2. There's no limit, it seems to me, under full details of what they ask for. So they would have to be persuaded clearly that passed the test and that they agreed with the concerns. But if you were able to persuade them, then they could ask for that information. So it seems to me to be strike the right balance and doesn't discount anything either.
Could 9.1 actually be a bit more explicit in terms of what I understand what you're saying, Mr. Hardy, about including but limited to, but the factors that are listed there are all very visual elements. Could it say limited, including but not limited to the size, type, external finish and colour, potential performance characteristics, whatever you want to, something like that. So it's in there in black and white.
Yeah, you can do that.
And it's then something that the council has an opportunity to get more details on if they so require.
I mean, at that stage, if the turbine's been chosen, the performance characteristics would be available. So why do you add that in? You could put, it's starting to sound like an exhaustive list, isn't it? Quite long, but including but not limited to size, type, external finish, colour and performance characteristics.
I think it's significant, Mr. Hardy, in the sense of it being an energy project, that performance characteristics are not just an additional line item, they're actually fundamental to the selection of the equipment that's going to be installed. So, I think that would come in,
but that would come in under, I mean, my view, I don't need to spend much more time on this, seems to me, but at 9.2, the turbines will be consistent with the turbine range assessed in the IAR. So you're going to get that anyway. It's just a provision of information point, but if you put in that performance characteristics in that list, I hope that deals with it.
Okay. Mr. John Campbell, you want to come in?
Yes, it's important not to get sidetracked by process and procedure, which is where Mr. Hardy has taken us. The objective here is one of transparency. You make an application for X. Is X delivered when it's installed? That's all this is about. It's about accountability of the developer who's imposing a great deal on this community in various ways, for the community to see that once the consent is granted, it is in fact justified by the performance. That's the almost philosophical objective which this is designed to achieve, not fiddling about with council permissions and process and procedure.
Yes, that's a different point. You see, that's one is provision of information, and absolutely, if we've agreed, it was covered anyway. But what Ms. Campbell's just said is different. That's a performance guarantee, and that isn't acceptable.
No, I didn't ask for a guarantee. I'm asking for information.
Well, a very thin difference seems to me. making sure that what's been promised is delivered and so on. That is guaranteed by the provision of information and the supply of turbines. That's what you are getting. The performer, how that chosen kit, which everybody understands then performs, is a different matter. And if it starts to edge into some sort of substantive performance guarantee, that isn't acceptable. It's not feasible for lots of reasons. So information, yes, and performance guarantee, no.
All I would respond by saying, rather than drag it out, is I haven't used the word guarantee once. I'm not looking for a performance guarantee. I'm looking for a means to achieve transparency for a perfectly reasonable objective, which is that the public is satisfied that what it has given up by this consent is in fact justifiable. It's not rocket science.
Thank you. I think I've got enough on
Got
that.
the points, yeah.
On to number 10, design of the substation and ancillary development. Dumfries and Galloway considers point 2 not to be necessary. The applicant suggests that it is, because it ties in with point 1. I think, does Dumfries and Galloway accept that point or not at this stage?
Mum, the wording has been slightly changed up to, and we're content with that now, and we do accept that that's relevant sub-clause of the condition. So we have no objection now to that wording.
Okay, thank you. Right, moving on to number 11, which is micrositing. Yeah. There's an acceptance that I think it refers to figure 1.28 should be 2.1a, so that's easily sorted. Is that right? Wherever 1.2a is referred to, it should be 2.1a?
2.1a, yes.
Yeah, throughout. 5 should be 3. So these are just technical things to sort out. There's a suggestion at 1c that it should also refer to planning authorities. So this is where written approval of ECOW in association with CEPA and planning, but also planning authorities, I presume, in a position between 50 and 100 metres. So this is involving the planning authorities in that. Is that still the position of Dumfries and Galloway Council?
Yes, ma'am. We would expect to be consulted on any micrositing between 50 and 100 metres.
I'm just looking at the applicant's response to this. There's no amendment other than those corrections. Do you want to add anything to that?
We've nothing to add to it, ma'am. We recognise the position of the council, and clearly it's a decision for yourself. It would be subject to the approval of the independent ECOW, but if you felt obviously that the planning authorities should also have a role in the approval of that, then obviously we recognise that is something that could be imposed.
Okay. And any turbo micros to be accompanied by wire lines, you're not accepting that particular point either?
I don't think it's so much a matter of acceptance, ma'am. I mean, I think it's recognised that if there was a proposal for micrositing, then the production of wire lines in a particular application for micrositing may well be appropriate. It is something that would be required by either the ECOW or indeed the planning authorities should they be involved. But it is essentially part of the mechanics and the information that would accompany an application for micrositing in many situations, perhaps not all, but in many. So I don't think it needs to be expressly referred to in the condition, I think is the applicant's position.
Okay, thank you. The Scottish Borders Council's comments. Just 1 second. There's a reference to avoiding microsited turbines appearing taller in the landscapes. So can you just explain what you're suggesting here, Mr. Shearer?
Yeah, that's fine. It was just what we're suggesting is just the condition reflects the hops micrositing condition, where it obviously it permits micrositing within the agreed parameters. One of those parameters should be that it shouldn't be positioned any higher when measured in meters above Ordnance Survey datum. I think this is so that we're clear that micrositing is fine, but if there's going to be micrositing carried out and all the turbines are going to move potentially 50 metres up the hillside, we're going to end up with something that looks quite different from what was assessed at application stage.
Can I comment on that? We've taken further instructions on that point, and the applicant's position, I think, is to propose that the applicant recognises that concern. However, there could be situations where either it is not an issue and therefore a total prohibition would be inappropriate, or indeed there could be scenarios where potentially and subject to assessment, wire lines or whatever, that there could actually be a benefit in moving certain turbines uphill. So what the applicant proposes is that Scottish Borders proposed wording there is amended to provide that there should be that wind turbine foundations should not be positioned higher when measured against the position shown on the figure, other than with the approval of the relevant planning authority. And that would allow the potential for that to still happen, but subject to control in each individual case by the relevant planning authority.
Yes, we'd be happy with that suggestion. Thank you.
I'm skipping over the MOD's comments on this particular one. And then Foresight Community Group have made some comments here. You agree with the councillors. Do you have any comments to make on suggested change to that wording and any other points you've made?
I don't think we have any points in relation to the change in the wording. In relation to sub condition 5, 11.5, you can see what is said there in the outer column. It's simply that the emphasis should be on building an approved development, which is approved prior to the inception of development, not the inception of commissioning. It seems likely, doesn't it, that when builders go on site, they know what they're going to do, and that micrositing won't be a matter of touch and feel as the development proceeds. But to overcome the anxieties about relative heights, which Mr. Shearer has spoken about, it seems to us preferable to have an updated site plan. Perhaps it should be a proposed site plan, because at that time it won't be built prior to. This draft reads prior to commissioning. With respect to whoever drafted it, wasn't myself. It seems to me this really should be prior to the inception of development, because once the turbines are built, they can't be moved. So prior to commissioning is really not important.
There should be your suggestion should be prior to commencement of development.
Yes, ma'am. I think I'd like.
Sorry, Paul.
Sorry, I think if you wanted me to, I think I'd like another go at drafting that sub condition. But of course, I'll leave it to you. It's ultimately your decision how it's drafted.
Mr. Keith Campbell, do you want to come in on that at all? Just on that comment about.
Thank you, ma'am. Yeah, I mean, I think the point we would make is that what I understand to be Mr. Campbell's position there, I think is contrary to the whole point of micrositing, that issues do arise once development has commenced, and micrositing exists in part to allow for minor amendments to be made to accommodate something that may be found unexpectedly. Micrositing is, of course, or would be subject to approval in accordance with the remainder of the condition.
Okay, thank you. Moving on to aviation safety, which is a matter that's agreed. And redundant turbines, 13. So it's really the date at which this covers. So Dumfries and Galloway is suggesting that should be short to 6 months.
Ma'am, just on that, there's been a slight change of wording, and we're now content with the position that
with the 12 months
that's set out in the amended condition.
I seem straightforward. Thank you. 14, ECOW and Foresight Community Group. That should be potentially appointed more than one single individual who cover these matters. I think the applicant is suggesting that the wording doesn't restrict more than one ECOW being appointed, and makes some changes in relation to adding reference to the peak management plan.
I think it does seem to us that the range of responsibilities devolved onto the shoulders of one person. Maybe too great for one person. I don't know if Ms. Jackson wants to comment on this, but it may be that the contractor, the developer, would recognise this and appoint additional ecological clerks as necessary.
Yeah, that was our point. I think here in the range of experience and it needs to be applied, and then Environmental Clerk of Works has been called up a number of times in the EIA to take on responsibilities for things like ornithology and peat management and flood issues, and potentially when I'm looking at archaeological issues. I think there's a range of experience sets that are required, and it was just a confirmation there that if required, then that may be more than one person who has to deal with those subjects on site over a 3-year period.
Yeah.
The applicant come in on that?
Yes, thank you, ma'am. Yeah, I mean, as we've commented there, the wording in no way limits it to an individual as opposed to a company. And indeed, the applicant's experience is that it will usually be a company that is appointed, which will have that range of experience that that was being referred to as required. So, and ultimately, of course, the ECOW has to be submitted to, or the proposed ECOW has to be submitted to and approved by the planning authorities, and that control exists within the condition.
Okay. Thank you. Anything further on that? Because there is this. Okay. Sorry. Did John
Sorry,
comment anything further?
Did you? I thought you asked a question there. Perhaps
It was just really, I'm speaking out loud, because if you were all in the room, you would get the sense that my mind is whirring and thinking, but it's harder in this kind of format. Planning monitoring officer is agreed. Construction and environmental management plan, the KEMP, so 16. Excuse me. A suggestion by Dumfries and Galloway that reference is made to Historic Environments Scotland in point 1. Currently, it refers to consultation with Nature Scotland (SEPA), and separate matter is raised by Mr. Campbell. Let's deal with the point made by Dumfries and Galloway first. So, the applicant's suggestion is, the response to this is that they haven't requested inclusion, and it's for the planning authority to determine who's consulted. Would there be any harm in adding them in, or do you think it's just not necessary?
No, we're content with the change to that one. It's okay.
The change being that it doesn't.
It doesn't need to include it, no.
Doesn't need to include it. Okay,
No.
thank you. That's still with. Mr. John Campbell, you've raised that Kemp should include details for methods of management of noise levels.
Yeah.
The applicant's response is it's covered by conditions 17 and 32. And also you've made a comment about blasting and they've suggested that's covered by condition 20. Are these still matters that you want covered under condition 16?
Yes, please, and for the following reasons.
Okay.
Construction noise tends to be a short, often disturbing, but essentially an episodic phenomenon. Wind farm operation noise is the opposite of that. It can be a persistent, long-term effect. The conditions which are proposed in conditions the later conditions relating to noise.
Operational noise is 32.
Thank you, 32. The conditions that are proposed in conditions 32 onwards are essentially concerning operational noise, which require inspection and analysis, to put it no higher, before any action can be taken. In relation to operational noise, as I say, these phenomena tend to be episodic, short-term, often very disturbing, but nevertheless of short duration. And so what I'm suggesting is that there ought to be a provision in the Kemp for the minimization of operational noise. It's not possible to build quietly, and everybody knows that. But just to give you an example, the reversing klaxon on a heavy lorry carrying fill is something that may only last for 15 seconds, but it's quite capable of waking you up if you're sleeping in a bed in a house nearby. That's not something which would merit a complaint to an environmental health officer who might not come out for 2 or 3 days. So I'm sure you see the difference. I'm not quite sure, though, that we have a satisfactory draft of measures to control episodic noise. I don't know if Ms. Jackson had anything to add to that.
Anything to add?
I don't have anything to add, no.
Thank you.
What's the applicant's response to this?
I don't think the applicant has any objection in principle, ma'am, to a reference to minimising noise subject to appropriate drafting. I mean, I don't know if Mr. Campbell has any drafting he would like to consider, or if we could have a look at it and perhaps suggest something to circulate. That might be the way to go forward.
Yes, it might require looking across the number of conditions and how they relate to one another.
Could I just ask something? Is that's noise other than operational turbine noise? I think that could just be specified. So what we're really talking about is the is noise. Is it, Mr. Campbell, Mr. John Campbell, in relation to construction activities and blasting and so on?
It's a 2 to 3 year construction period.
Yeah. So I think that would just need to be set out, wouldn't it? Would be
it needs to be set out, and it is quite difficult to draft. But I do have a little bit of experience of complaints of this nature coming forward, and reversing klaxons is one of the features. Now, I'm not suggesting for a minute that the contractor would want to silence all his reversing klaxons, because that would be breach of another regulation somewhere. But it's possible to phrase a condition in such a way that operational noise is minimized where possible. I'm not going to...
Does it need to go into that level of detail, or can it not just say that it deals with noise and then, open brackets, other than operational turbine noise, which is dealt with by condition 17 or 32?
Exactly. I agree with you in principle, yes.
And then the scheme just is dealt with, and that can descend to the detail. I don't think you need to go into that in the actual wording of the condition, as long as noise is covered.
I agree with you in principle. I wouldn't want to go into the detail because
Yeah.
there are hundreds of different kinds of noise.
Yes, exactly. So fine. No, well, we're happy with that.
Could you, what you're suggesting there, could you provide a form of words as, I'm just wondering that we've discussed a couple of things here that might need a few little tweaks here and there.
Yeah,
And things that we agreed. It'd be helpful at the end of this session to have a revised version of this document with the
Of
final.
course, what I was proposing was something along the lines of details to control noise, open brackets, other than operational turbine noise controlled by conditions 17 and 32, something like that.
Okay.
Yeah, I think we can do a bit better than that, but yes, the principle is fine.
Okay, let's have a look at that one. Construction hours 17, and this is a matter. This is also a committee group suggesting that these hours should be slightly less, Monday to Friday and on Saturdays. Now, applicant's responses, these are in accordance with the HOPS conditions. Is there anything further anyone wants to add, or should I just leave that with me to have a look at?
Unless Ms. Jackson has anything to say about it, I don't have anything to add to what's written there.
No, I don't have anything to add.
Archaeological works. And this is from
It's a very, I might just observe before we leave this, it's a very interesting phenomenon of this locality, how far noise travels on a still day, because of the shape of the valley. And even with the A7 running up the middle of it, traffic noise is almost incidental, but at a surprisingly large distance without passing over water, noise travels an extremely long way, or seems to do anyway. Making allowance for my own deafness, I still hear
it. Condition 18, as I read it, is not an objection of any kind from Stock Environment Scotland, so it's not something we need to cover here. And peat management plan 19. Suggestion from Dumfries and Galloway, including the Kemp. Is this, rather than have a separate condition, are you suggesting?
Ma'am, we're okay with that. It was just a suggestion, but we are happy for it to be a standalone plan. Yeah.
Okay. And also committee groups comments on this one. I'm pulling this away because it's really small print because I've had to put this out on an A4 paper. So apologies if I'm peering at it.
I don't think this is so much an objection as a series of comments on how the peat management plan would work. Ms. Jackson may be able to help.
Yeah, it's more with respect to a peat management plan being quite time dependent in the sense that it's to do with drying out of the peat. So there's an element of integration of the peat management plan within the construction plan that has to happen if it's genuinely going to happen on site. I mean, it's easy to write a peat management plan and then write a construction schedule, but it's not quite so easy to combine the two realistically to make both of them work. So it's just comment, it's an observation, to be fair. It was just that there needs to be an integrated approach to how those plans are actually executed with regard to the overall schedule for construction.
There's nothing you're specifically suggesting change within that condition. It's really the content and the timing and various things like that.
Yeah, it would probably be evolved during the detail of those plans and how the plans are merged together into the overall construction schedule. But perhaps the wording there addresses that adequately.
Borough pits. No, 20. Representative Galloway suggested wording here. Is that still your position, or are you altered since this was produced?
Ma'am, there has been changes to the wording of this condition, and we're content with the revised wording, which is now in that first column.
Okay. There's a suggestion by the applicant here to put in response to Fullside Community Group's concerns around point F there, to add in a system of prior notification of blasting operations to the residents of specified properties in the vicinity of the development. And at point 2 there, timing of when blasting can actually take place. Does that satisfy some of your concerns, Ms. Jackson?
Yes, it does. If that's applied, then that was the concern, that there would be adequate communication and prior warning.
Management plan, that's agreed. And the group as well. Water quality and fish population monitoring. I think the suggestion here that this is actually something which is dealt with under private water supply. Condition 23 is very specifically about this water quality. Am I right there in terms of, I think, Mr. Hardy or Mr. Campbell, sort of that's what you're suggesting?
Yes, our thoughts on the comment from the Foresight Community Group was that they seem to be talking about private water supplies to residential properties, which is dealt with under condition 24.
Ms. Campbell, can you just clarify, is that more condition 24?
I think Mr. Keith Campbell's right. Sorry, just a second. 1 second. Sorry, the note to condition 23 does appear to be talking about private supplies. So
What's the issue under 24?
if we can probably delete the note under 23.
Yeah, it's this point, I think, you're wanting all properties covered.
Well, the thrust of 24 is that there should be risk assessments for those who depend on private water supplies. And that risk obviously is one that has to be made before construction commences.
There was a reference within the EIA to some properties not being addressed in the private water supply issue because they were connected to the development. There was some filtering of properties that were covered in some of the discussion. And we felt if this goes ahead, then obviously all property water supplies need to be protected, regardless of how they are connected or not with the developer and the landowners.
There's some suggestion that any property connected with the development, I don't know if the expression financially involved was used or not, but I think that's the thrust of it, ought to be able to put up with private water supply pollution, whereas those who are connected can't be expected to do that. That doesn't seem to me to be a reasonable distinction to make. Should be a risk assessment of all PWSs before this project is signed off for commencement of construction.
Yeah.
Can the applicant clarify on that, if that is the case?
Yes, ma'am. I just checked, and all properties, including those financially involved, were subject to the PWS assessment in the EIA. Indeed, I understand that the 2 properties that are named in the condition are financially involved. Yes, that's correct. So it did include financially involved properties. It included all relevant properties, and obviously we've made comment there that it would be unnecessary and disproportionate to expand the condition to include properties which are not assessed at being at risk.
Okay, so just to clarify, those that were financially involved were included in your assessment and have been looked at, and but you don't consider that all properties that have private water supplies in the area that haven't already been assessed should be included in this condition.
Ms. Jackson has something to say, I think.
Yeah, Ms. Jackson, do you want to come in?
And just the conclusions of the EIA were regarding which properties were at risk. I think it's important that we maintain that monitoring function across the properties which are receiving their private water supply from that source, regardless of the outcome of the actual at risk or not at risk. I'm afraid that these things evolve, as you said, in terms of how the construction will proceed, and there's a possibility that anyone who has water supplies from that location could suffer a change in the quality of their water. I'm not very comfortable with the idea that this filtering that was carried out in terms of the properties which are considered at risk or not at risk should continue into the next phase of the project. I think it should be a monitoring function that is a requirement that's carried out regardless of whether this property was considered to be at risk. That was my position on the subject.
What would someone do if they had, private water supply was interrupted, but they weren't on that particular list? As just asking the applicant here, what's the course of action for someone who's in a property like that?
I mean, if it's not related to the development, it's not a matter for the applicant to deal with, I think, is the.
I understand that, but what if, and things can happen, and I appreciate you've done an assessment, but is there a contingency plan that if a particular property does unfortunately have an adverse effect from development, what's their course of action?
At the moment, there isn't, because that's the nature of the assessment. That's the nature of the assessment. That's the calculation that's been made. I think what was said as a sort of general protection or general monitoring isn't proportionate, nor is it lawful. I think if there's no effect to be monitoring just because people want that to happen. I suppose a hybrid would be a complaint-driven process, whereby if there was a property that had got interruption, then that could be investigated. So that would be a sort of a middle course. We don't think it's necessary.
Is there a condition that could be, or part of this condition that could be written to accommodate that?
Not at the moment. I think that could be added in if that were thought. No, we're not saying it is necessary, but if you took the view, but it would be proportionate response would be to go on a responsive basis rather than an unjustified, well, we should just monitor anyway. So if that would be of interest, then we could perhaps look at some wording that we could propose as a proposal.
I think it would be similar in terms of when you're looking at other aspects of the development where you've got unknowns that things that might not be unexpected. And I appreciate the assessment's been done in accordance with the methods that you use. There could be something. Yeah.
I was thinking about noise, because that noise obviously is complaint driven.
Exactly.
So what that you're not just monitoring everywhere for the sake of it, but if there is a problem, then there is a system for investigating. So there's a proxy with that. So we don't think it's necessary, but but you've got that point. But we'll come up with some words to just to consider as a hybrid.
Okay. Yeah, I'd like something to consider.
Yeah, thank you.
Campbell, John Campbell.
There's plenty of experience of complaints about interference with private water supplies being causally related to a wind farm development. But on the hypothesis that you've advanced, if somebody was assessed and found to be not at risk, and then something did happen and it was proved, then the environmental health officer has plenty of powers under the EPA 1990 to issue notices, even in an emergency, to cause rectification.
I suppose if it's direct action that then the applicant might be in a position to do and to make it's that connection between that quick reaction. Yeah. So there's a legal condition.
Yeah, the beauty of that service is that it's free
Mm-hmm.
and available 24 hours a day. So it seems to work.
Okay. Anything further on that before we move on? Okay. That was 24. Third protection. Excuse me, it's getting really warm in here this afternoon. I'm warming up. Right. A reason, I think just a reason for it has been added, which to ensure the protection of breeding birds. So I'm happy with that. I think the point made, Mr. John Campbell, about the eCal function, I think you've made that before, so I understand the kind of wider remit that they might have. Construction traffic management plan. Minor typo, but nothing there that we need to concern ourselves with at the moment. And 27, abnormal loads. Yeah, so reference to adding consultation with Transport Scotland and the Local Roads Authority. It's done.
Mr. Hardy might be able to tell us if necessary to liaise with the police as well for abnormal loads. Sorry about the hammering. I'm sorry about the hammering in the background. I've got somebody on my roof just above me.
I did wonder where the hammering was coming from. Yeah, on that point, Mr. Hardy, is that?
I think the answer is that this is a model condition. It's not in the model condition. And I think, Mr. Campbell, Keith Campbell, do you want to just
point out that it is, of course, a submission and approval of a plan is required, and if liaison with the police was required or police involvement was required, then that would presumably be reflected in the plan, and the councils would be in a position to require that to be in the plan.
Okay. So some traffic accommodation works and abnormal load accommodation works.
I think Mr. McTeer has something to add there.
Oh, Mr. McTeer?
Sorry, ma'am, just on that last point about the police involvement with the roads and everything else. I'm not sure about Scottish Borders Council, but Dumfries and Galloway consult Police Scotland as part of any submission that comes in for traffic management plans and the movement of abnormal loads as well.
Okay, so that would come into that. Is it the same for Scottish Borders, Mr. Shearer? Do you know?
Yes, we tend to do that through our roads planners. Yep.
Okay. 30 heavy goods vehicles. So what we've got here. It's an hours, changing of hours issue. The applicant says that they're following model condition 15. I'm happy to just to have a look at this. Don't think I need any more comments from anyone on this. Post for construction roadworks 31. Dumfries and Galloway suggesting should include post decommissioning too. Anything more you want to say on that, Mr. McTeer?
No, ma'am. The amendment is to include the works in condition 36.
Oh, yeah, it is. Sorry, yes, I just noted.
Yeah, we're content with that one.
Okay, thank you. Operational noise. Yeah, the applicant's suggesting taking out the word justified and just having complaints. So there's no kind of judgment made as to whether something's justified or not. Presumably you're happy with that, Mr. John Campbell?
Yes, yes.
Yes. 53, decommissioning. I'm just wondering where we get into with these. So suggestion from Dumfries and Galloway is it's based on the date of first commissioning rather than date of final commissioning. Can I get your position on that just now?
Ma'am, we do have a concern about the wording of this condition. Whilst it is in accordance with the model wording, that the actual definition in the glossary of terms of date of final commissioning in the model conditions is defined in a different way than is defined in the glossary in this draft. And the model conditions have date of final commissioning means that the earlier of the date in which the electricity is exported, as is set out there, and then they also have 2, the date following 18 months from the date of first commissioning, and that is obviously to avoid a situation whereby a developer could perhaps not put in 1 turbine, and then the date wouldn't start running until that was done. And so, as it currently stands, with the definition of final commissioning, that would not that would be a possibility. We've suggested that it could be first commission. The date of first commissioning there. The alternative would be to amend the glossary of terms to the definition in the model wording, with that the date falling from the date of first commissioning, and it being the earlier of the 2.
The applicant.
Ma'am, the applicant recognises that concern that Mr. Armstrong has just expressed, and again, we'd be happy to propose an amendment that ensured that scenario that he described was not the case and included the either or, the final date or the 18 months from the date of first commissioning. So we'd be happy to tweak the definitions to reflect that concern.
Okay. The reason for condition compensatory forestry planting has been added in. It's nothing further than that. 35, ECAL, decommissioning, restoration, aftercare. It's okay. Right, 36, site decommissioning, restoration, and aftercare. Dumfries and Gallery suggests that post decommissioning works should be included in this. Scottish Border suggests SEPA should be included as a consultee. Anything you want to add on that, Mr. McTeer?
No, the post decommissioning works that we were looking for have been added into the amended conditions, so no, we're content with that.
And it's just a reference to SEPA's consultee, but that is which the applicant doesn't feel is necessary, and the planning authority can determine that as part of the consultation. Nothing on 37, little typos. And 38, Dumfries and Gallery suggesting a new condition, and which I think is already covered, am I right? Under part 5 of condition 9. So would it be?
Yes.
It is duplication, right? So we don't need that new condition.
No, ma'am.
Right, we're at the end. Is there anything further I need to hear around conditions? Part of this particular session. Appreciate we'll be revisiting this when we've had evidence from the Ministry of Defence.
I don't think so. I mean, a very high level of agreement. There's some tweaks. So what we'll do is get a revision put together, including those comments, and then circulated. Hopefully, we'll then get to a point where they can be agreed.
Yeah, I appreciate that being done in a reasonable time frame. Yeah, but it could have something which is the agreed position of people. If there is still any disputes in there, then obviously just be highlighted, which is fine. But I'll have heard.
We should.
On that.
Yeah, we'll circulate basically at the start of next week, Monday, Tuesday next week.
Mr. Keith was just telling me he would hopefully get that circulated by the start of next week. Can I suggest that's we aim for the 29th, which is the date for?
That's fine. Yes,
the other submissions
for the final. Yeah.
Ma'am, I suppose the only issue in relation to that is obviously other parties have got to get their final submissions in on the 22nd of August, so we wouldn't have seen the next version. Is it the start of next week?
Yeah.
Yes. Sorry,
15th.
just 15th, right?
So we've got a week in. And we talked about further written submissions. Mr. Hardy, you said you were maybe going to turn something around a little bit quicker in terms of your response to allow Mr. John Campbell to then
on the
do
carbon calculation point.
Yeah. So I think we were talking the week before the 22nd. So
which is the 15th. So the start, get as early as we can into next week. Yeah. End of next week is the 15th, 16th. Just as soon as we can next week is all I can say.
Okay. I think that's everything for today.
It's just aside from these matters, it was before we left this call, was to give you as much of an update on Estelle Muir as I could. I don't know whether that's an appropriate time now, if you want to wrap everything else up and then just turn to that as the last thing. I don't know whether there's nothing else from us on our side as on conditions, or we're happy.
Okay, I'm happy to wrap up this is the end of the inquiry, and then I'll take any other matters. Okay, Mr. Hardy, yes.
Right, so Estelle Muir, as you know, there was the postponement on the 21st of June, a report that there was a meeting between the parties' experts scheduled for 22nd of June. In advance of that meeting, there was a list of suggested points for discussion shared with the MD. That was cross-referenced to paragraphs of Dr. Bauer's inquiry report. And the purpose of that list was to seek to identify points which, firstly, based on Dr. Bauer's inquiry report, the applicant considered there to be potential to reach agreement. And then secondly, those where there was the potential to make a material difference to utilisation of land in the vicinity of the array for renewable energy. So those are the two drivers. That meeting was held on the 22nd of June and was very helpful. Direct engagement between the experts. Topics on the list were discussed. The MOD shared a revised statement of agreed matters on the 30th of June. Draft minutes were shared on the 18th of July, and then an action was for the applicant to produce the proposed scope of work for next steps and to share that with the MOD. Purpose of that to focus on a number of specific areas where, following the discussion between the experts, it was considered that there was the potential to reach further agreement, and which would make a substantive difference to deployment of renewables. Revised draft SOAM shared on the 18th of July. Next thing that happened was very recently, the 9th of August, the MOD came back wanting an update on the proposed scope for next steps. Dr. Bowers wants to review the list and any scope before arranging another meeting, and confirming that it expected to return comments on the SOAM and on the expert meeting minutes as soon as possible. So that's with the MOD, so the SOAM and the meeting minutes. I'm just being told by Mr. Keith Campbell they will return this morning. There you go. So there's been movement which I didn't know about because I've been concentrating on landscape this morning. So they've come back. Applicant then confirming 10th of August. Next steps, the scope would be provided in the week commencing 29th of August. And I think, as a general feeling, there was a positive feel about the experts meeting. And so the important thing is to take time to prepare a considered scope of works which will allow the parties to reach an agreed way forward. Preparation of the proposal is quite input over the summer break from Professors Tuckwell, Stiles and Macbeth. The applicant has requested the MOD's comments on the SOAM and minutes prior to the week commencing 29th of August in order to ensure that they can be taken into account. And just heard they've come back this morning. So, subject to any direction from you, Ma'am, our suggestion would be to share with you the SOAM, so the agreed statement, if that's where we get the expert meeting minutes, and the proposed next steps, the scope during the week of the 29th of August. Formal update to be provided after the meeting, to be arranged for the experts to discuss the scope of work. And we think that would be an appropriate point for the next steps in the inquiry process to be set out. So a number of procedural things there, and then the important point of substance really is the scope of works, which is coming out of all of this. That scope of works is designed to be an agreed pathway to allow the sides to come together. So I think the messaging is, as I've just indicated this morning, things are happening. Its momentum is forward. It's positive. These things do take time. They're complicated. There's also obviously summer holidays, but it has been done. And by the 29th, the week of the 29th of August, that's what we would hope to be in a position to provide you with. And at that stage, we'd then invite you to make a suggestion for the procedure for the rest of the inquiry session on Esteelmuir.
Okay, that's really helpful. So expect something in that week commencing the 29th. That takes us in terms of any planning of any oral process, if that's still necessary, and I'll have a look at the information that comes in. Yep. And based on what both parties say. We originally indicated, MOD originally indicated, a thing around 6 months. Is that still, and I appreciate I'm not speaking to MOD just now, but do you get the sense that that is still their feeling, or are we talking about shorter timescale?
I don't honestly know. I've not seen, as I've just betrayed, I haven't seen what's come in from the MOD. So I don't want to say anything out of turn.
I can hear from you separately on this. It doesn't need to be something we can discuss today, and I can hear them both from Douglas Milne as well.
Yes, I don't want to go say things that I haven't taken instructions on. I don't fully understand, but I think the messaging is things have been happening. It's positive. Momentum is forward. 29th of August is where you're going to get that information. And at that point, probably take a view on when and how the inquiry procedure goes forward.
Okay, that's helpful. Thank you. All right, there's nothing further from me. I will see some of you tomorrow on the site visit at 9:30. And thank you very much for your help and input over the last few days. And that finishes the session. Thank you.
Thank you, ma'am. We're most grateful.